everybody, and welcome to Night Court. It's a Monday. How does everybody feel today? Hopefully, all right. I don't know. Today is not a full moon, but it sure as hell felt like one. Well, I think it's time to get the 10,000-pound elephant out of the room, shall we? I mean, and I know that Brandi's going to hit on this, but it's pretty obvious. We hit 10,000, which is crazy. Thank you all so very much. You sharing, telling friends, we are indeed 10,000 strong. Now I just need a quarter of them to show up to Night Court. But yeah, wow. It's wild. It's wild. I think I said this before on the stream. The average YouTube channel, if it gets lucky, is 1,000 a month. This is crazy. So, if there ever was a benefit to a Monday, boy, that made it better. Boy, howdy. It was very Monday-ish. Hello, Amy H51. Hello, Kelly P. Linda, hi. Captain, thank you. Whoop, whoop. Thank you very much. Thank you. That's very exciting. I saw some folks. Thank you. I saw some folks asking, is Brandi coming back? She is. She was on her way back. She stayed an extra day in Florida. Or in Florida. She lives in Florida. She stayed an extra day in Orlando and drove back. She should be home now. So she'll be ready to go. That's awesome. That's fantastic. Thank you very much, Jackie D. What else we got going on? Let's see. Yes. All of it. Except tonight's a water night. Thanks, Angie. Hello, Sunny. It was a long weekend. It was. I got a lot of cross-stitching done. That's right. I said cross-stitching because I am now cross-stitching. Because I need to work on something that keeps my attention on one thing and just kind of work on that. Hello, Jaded. But I did do a lot of that. We had hurricane, tropical storm, depression, Ophelia come through. So a lot of branches down. So the power kind of went, but it stuck around. So we're grateful for that. Dancing the night away. Oh goodness. Hello. Hi, Cheryl. Thanks for coming in. Thanks for being here. Appreciate it. Thank you. Get that seat. Candace. Just I don't know. You said, I read that. It said hangover. And then I said your name so loudly. I am so sorry. Candace went to an awesome concert. She went to go see Rob Zombie and Alice Cooper, which is amazing. And so, in that note, we will celebrate with a no more Mr. Nice Guy. Right? No more Mr. Nice Guy. Can't wait to see him again one day. All 10, yes. All 10, maybe not all 10,000. Dean came for the party. He's staying for his own jokes. Ooh. No big toe. I've got tendinitis in the toe. Toe-tendinitis. That's what I got. I needed to behave tonight. Hey, hi, Lisa. That's well, ma! I love the fact that I now have that one. When? That's a great question. I don't know yet. I have no idea when. No idea when. Jimmy, we're glad you're here. I'm glad you've been here this long. Another YouTuber stayed and went to Halloween Horror Nights. Oh my gosh, that would be me. That would be me for sure. It's so much fun. I like the fact that I have something tangible after focusing on that thing, and so I feel good about it. The first one I did was it says I can't adult today. The second one I did was for Brandi. Shh. So I can't really tell you now. And then I am now doing a Baby Yoda Grogu tiny one, and then I have a big announcement one that I'm making for my brother-in-law and his baby. I don't know. I decided that I was going to Vogue. So very excited about that. Super psyched. Hello, Jen. Oh, it's an exhausted hangover. Yes, been there, been there. Me too. Not very many people have seen the movie 13. Is it 30? No, 31. Not many people have seen 31. It's such a good film. Such a good film. It's really dark though, so not 7 minutes. So I'd say not. You're in the realm. You're in the realm. I must see Brandi clog. What she's gonna have to do is she's going to have to put the Lucy cam on her clogs. We're gonna have a clog cam. Hi, co-host with the most. I saw that picture. Terry posted a picture on Terry True Crime, which is our True Crime and Wine Time Twitter, and it's a view of her office from outside, and it looks so cool. It's just the neon, the lights, it looks fantastic. Looks fantastic. Oh, good grief! Yes, please ooh, lions, mountain lions, and tigers and bears. That's true. That is true. Yes, tangible results are very helpful. They make it worth it. Make it worth it. All right, let's see here. Hello, Thor Johnson. Welcome in. Welcome in. I'm going to certainly try. That's closer to me for sure. I think that I'm going to be trying to do that one, and then I'm going to be trying to do the True Crime Paranormal Podcast Festival. That's in Denver. Mike and I from Brew Crime's already got their tickets. They're already featured on the website, which is kind of cool. So I'll be there for that one for sure. CrimeCon possibly. It's really funny. I felt terrible because like everybody was talking about everybody at CrimeCon, and I was like, I hardly know any of these folks. Oh man. I don't think so. Pretty sure not. So that's gonna be a Brandi. That's gonna be a Brandi special. I want to go too. I think we're gonna see what happens, but if enough of the 13th jurors are going to either of the conventions, we could do a meetup, which is kind of awesome. Hello, hey. Yes, Dub H, the man. It's the True Crime Paranormal Podcast Festival in Denver. It's gonna be good. It's gonna be good. Oh man, that's for sure. All right, so let's talk about tonight. Here's what we're gonna be doing. Literally the trial. I don't want to. I want us to just. We're gonna marathon through this. We're gonna go through the sentencing. We're gonna go through the victim impact statements. So tonight's gonna be a little emotional. I think I said that on Friday. So yeah. So we're gonna be doing a little bit of. We're gonna be doing a lot of bit of that. But before we do that, I think it's really important to do what we typically do. Oh, Virginia, I'm so sorry. It never fails. I always forget to take the banner off, and I always feel bad because I cover somebody stuff up. I apologize. I apologize. I will fix it for next time. Hello, Bruiser. You lurk away. I'm glad that you're here. I am so glad, so happy that you are here. Oh man, what a wild time. Also, yes, congrats to the top 5. Hopefully you enjoy your stuff. You can take it home with you this time. It's a celebration. Why not? Also want to let you know that we 13th Juror is still the top corporate sponsor for the Boosterthon, thanks to you all. So that's pretty cool, right at the top of the list. That hasn't changed. So that's pretty doggone cool. And then let's see. There was one more thing, and I've already forgotten what it was. Oh shoot. Well, obviously it wasn't that important. It obviously wasn't that important. Oh well. Oh wait, no, I remember what it was. It was something that this is what it was. Yeah, Thursday was a rough time. Thursday was a rough moment in my life. And it had everything to do with me. Yep. Nope. What's up, 80s music man? Welcome in. And I said, welcome to the show. Oh, man. All right, you enjoy those bushes. Enjoy those bushes. Hopefully you can find like some kind of pillow or something. That would be good. That would be good. We've got a lot going on. Yeah, I'm going to talk to Brandi about what our plans are for the next thing, and then we'll definitely let you know in all ways, shapes, and forms, or at least as here. We'll let you know. We'll let you know here. Yeah, and before I forget, night court's in session, so I guess everything before that didn't count.
Not today, Satan. Not today.
I don't know. All right, here we go.
Seated. The record will show the presence of the jury, the defendant, and all counsel. Ladies and gentlemen, we are going to begin the penalty phase. The bailiff will distribute a copy of the preliminary instructions for the penalty phase. Once everyone has a copy, I will read them to you. I invite you to follow along with me. Again, these are your copies. Feel free to write on them. They will be shredded at the end of the trial. Members of the jury, at this phase of the sentencing hearing, you will determine whether the defendant will be sentenced to life imprisonment or death. The law that applies is stated in these instructions, and it is your duty to follow all of them, whether you agree with them or not. You must not single out certain instructions and disregard others. You must not be influenced at any point in these proceedings by conjecture, passion, prejudice, public opinion, or public feeling. You are not to be swayed by mere sympathy, not related to the evidence presented during the penalty phase. You must not be influenced by your personal feelings of bias or prejudice for or against the defendant or any person involved in this case on the basis of anyone's race. Express my feelings to the state's evidence, where the verdict will be read, which objections were sustained, making the defendant.
Come on, Sherry Stevens.
Party presented it. Each party is entitled to objections that they deem appropriate. These objections mitigating circumstances. Mitigation instructions I will give you on the line. These preliminary instructions will remain in effect unless changed by the final instructions. Mr. Nerman.
Thank you, Your Honor. Ladies and gentlemen, the verdict that you will render at the end of this phase of the trial will determine whether or not Jodi Arias will spend the rest of her life in prison.
Objection, proper argument. It's for the judge.
Approach, please.
He made it one sentence
Your
in.
verdict, ladies and gentlemen, will determine whether or not Jodi Arias spends the rest of her life in prison, or if she's sentenced to be executed. That's what your verdict will determine. And make no doubt about it. As the judge just said to you moments ago, the verdict that you will render is not a recommendation.
Bread and butter in terms of this is his
The
whole
judge
argument.
is not free to disregard it.
Don't kill her.
If you sentence Miss Arias to
Unalive.
life in
No
prison,
stay.
she will be sentenced, her life sentence. If you sentence her to death, she will stand at this podium and be sentenced by the judge to death, to be executed. That is the decision before you. Obviously an important one, and in many ways a pretty simple distinction to understand life versus death. But what's maybe not so
She looks a little
simple,
defeated
because
now.
it's a little different than the prior phases of this trial,
And stop faking it.
is the fact that things work a little differently. In the first phase of this trial, there were presumptions and there were burdens, right? Ms. Arias was presumed to be innocent, and the state had to prove beyond a reasonable doubt that she wasn't, that she was guilty of first-degree murder. During the second phase of the proceedings, the issue was the aggravating factor. The state had the burden of proving that aggravating factor. At this stage of the proceedings, the law does not presume what sentence is appropriate. The state does not have the burden of proving that a death sentence is appropriate. And Ms. Arias doesn't have the burden of proving you that a life sentence is appropriate. Each and every one of you, those who deliberate, has to make your own moral assessment on what verdict is correct. And you will hear evidence in that regard, and we'll talk in a few minutes about that evidence. But as your jury instructions indicate, each and every one of you get to make your own moral assessment of what sentence is correct. Now, you've heard during the judge reading, when the judge read the jury instructions to you, about mitigating circumstances, about mitigating factors. So as you hear the evidence, we need to talk a little bit about those, what they are and how they're used, or how they can be used by you. First of all, Ms. Arias does bear a burden of proving to you by a preponderance of the evidence, more likely than not, the aggravating factor, the mitigating factors. And then you decide if those mitigating factors are substantial enough to call for leniency, to allow her to live her life in prison. The mitigating circumstances is a term you're just starting to hear now. And it's important to understand that while the judge has read a list to you, and we'll talk about that list and the evidence that's going to be presented to you in a few moments, the witnesses that will take the stand and talk to you, what you will learn during this phase of the trial is not about the Jodi Arias that was living her life in 2006 after she met Travis Alexander. You will hear more about her life before that point in time. What brought her to that point in time, so you can understand whose life you're deciding whether it should be terminated or not. The law gives you the benefit of that understanding. And through these proceedings, we will give you the benefit of that understanding. And Ms. Arias will have the opportunity to talk to you in a different way. Not about what happened, but about who she is.
Finish her!
And in that regard, ladies and gentlemen, it is important to understand the last paragraph that is displayed to you. Mitigating circumstances can be found from any evidence presented. Any evidence presented during the trial the aggravation phase or the penalty phase. What that means, ladies and gentlemen, is that all the evidence you began hearing back in January of this year is evidence that you can consider. It need not be presented to you during this phase of the trial. There may be something that both parties overlooked, a piece of evidence that you think, boy, that's a reason, that's a reason why I think she should get life, that hasn't been presented to you. And you alone can decide that that is a mitigating factor substantial to call for leniency. And you'll notice I've been saying you and you alone. I said that a couple of times, and I said that for a reason. Because unlike those prior phases, in the prior phases, each and every one of you had to agree on the verdict. You had to agree that she was guilty of first-degree murder before you could deliver that verdict. And things work a little differently in this phase. You do have to agree, if you can, as to either the ultimate outcome, be it life or be it death. But you don't have to agree on the reasons. You've heard mitigating circumstances about Miss Arias' artistic talent. One of you could find that to be mitigated. Another jury could say, that doesn't matter to me. But her lack of criminal history does, and that's a reason to give life. And you don't have to agree on those mitigating factors as long as you agree on the verdict. That's what I mean when we say, and the instructions say, your own moral assessment of everything you've heard since the trial began. Again, as you process this information, understand that mitigating factors are factors to the basis for a life sentence instead of a death sentence. So when you hear this evidence, and keep in mind, when you hear from these witnesses and when you hear from Miss Arias, this isn't about an excuse or a justification, but factors about Miss Arias' character, her history, her record, or as you have heard, frankly, lack of record, and the circumstances of the offense that aren't an excuse or justification, but fairness and mercy come into play. In your moral assessment of what the right thing to do is, fairness and mercy come into play. Now, listed before you are 8 mitigating factors. The defendant was 27 at the time of the offense, and she had no prior criminal history. You've heard evidence to that effect already. She was born there was a driver's license admitted of her birthday to July 9th, 1980. She has no prior criminal history. That was presented to you during the trial. Number 3, that she was a good friend. You will hear from 2 witnesses during this phase of the proceeding from Miss Arias. You already met one, Daryl Brewer. You recall you met him back in January. He was a longtime boyfriend of Miss Arias, and in fact, the one that preceded Mr. Alexander. You spent some time together. You'll hear about the role she played in his life and in his son's life as well. You'll also hear from a friend of hers, I must quite say lifelong friend because they lost touch later in Miss Arias' mid-20s when she got together with Mr. Alexander.
Anymore.
Her name is Patty Womack. She will talk to you a little bit about the Jodi Arias she knew, her upbringing. She will talk about the lack of support Miss Arias had from her family. She will describe that for you from her observations. You've heard during the course of the trial that Miss Arias suffered abuse and neglect as a child and as an adult. factors 6, 7, and 8. Trying to make the best of her life, trying to improve herself and her work as an artist. You heard a little bit during the course of this trial about how prepaid legal is one of the things that
Deep
Miss Arias
sigh.
is trying to do to improve herself and make the best of her life. How even her desire to join the Mormon church was in that line.
Game over.
Her desire to improve herself, to maintain her goals of motherhood, marriage, and having a bit. We'll talk about that a little bit as well. And talented artists. At the end of these proceedings, Miss Arias will talk to you. You'll see some of her artwork. You will see her work. You can judge for yourself whether or not that is proven to you. But as it relates
Only
to those
for
final
herself.
factors, those final 3 factors, Miss Arias will discuss those and talk to you about how she viewed her life. And she'll touch on all these factors in a way that she was not permitted to beforehand. One thing that you will not see in the mitigating factors or even the aggravating factors, one thing specifically
To everybody who
precluded
recently joined in.
from your consideration as you hear this evidence, ladies and gentlemen, is that she's been convicted of first-degree murder. It's not a mitigating circumstance. It is an independent consideration, despite the conviction. That means we've gotten to a point now, you remember the first day you came in for jury selection, probably not the first day after you filled out the questionnaire. All the parties sat before you and you had a questionnaire and it said, if you got to a point where you would have convicted someone, and then that back then it was hypothetical, right? If you had convicted someone of first-degree murder, even considering that fact, could you consider a life penalty to be appropriate? And each and every one of you is here because you said that you could deem a life penalty appropriate, even after that premeditated first-degree murder and even after aggravating factors were found. And that's some of what that says there in that paragraph. But now, ladies and gentlemen, ultimately, that question that we pose as a hypothetical is real because she's right here.
It's okay.
This is the girl right here that you pledged when you were selected as jurors that after hearing or after possibly convicting her of first-degree murder and finding aggravating factors, that you would consider giving Miss Arias life. That is what you committed to each one of the parties to do. And ladies and gentlemen, that is what we expect you to do when you hear all the evidence, when you consider all the mitigating factors, when you understand who Miss Arias is, you will understand that life is the appropriate penalty.
Mr. Martinez.
Oh, Mr. Martinez.
Today, in these proceedings, defendant is asking you to consider certain aspects of her life. And in fact, those aspects of her life have been read to you by the court. The defense counsel has addressed them to you, and there were 8 of them that were set out for you to take a look at. With regard to those 8 factors, one of the things that defense counsel indicated to you was that you can find other factors from the evidence that's been presented. However, the law is such that you are not to act as an advocate or an investigator to try to find mitigating factors.
Objection in this case of law.
Overruled. Your duty is to take a look at all of the evidence and consider it with regard to fairness, and that's something that defense counsel also indicated to you. And that fairness goes both ways. It goes both to the defendant, as he pointed out, but also to the person who isn't here, Travis Alexander. And if you take a look at the evidence, those 8 factors that you have there for you to take a look at, and that the defendant who has advanced them must prove by a preponderance of the evidence, one of the things that you should or know when you look at them is that they're flawed. The reason that they're flawed, those 8 factors.
Approach, please.
Isn't the argumentative part?
Continue.
One of the
implied.
things that the jury instructions that the court read to you was that with regard to this mitigating factors, the connection or lack of connection to the murder may impact the quality. And that's the reason that these factors, as they are set out to you, are not really worth any, are not of any importance. For example, if you take a look at this indication, and this was put up there for you, that the defendant was 27 years old. Well, there's no connection, if you will, between her age and the fact that she took a knife and stuck it into Mr. Alexander's chest.
Objection, argument improper.
Approach, please.
Probably something like this.
You may continue.
There is no connection between her age and what she did to Mr. Alexander. And one of the things that the previous
I almost went full
page on
Kermit
page
on
6
that one.
indicates is
It's
that
about Pachulia.
that connection is something that you may consider. For example, the fact that she has no, indicated has no prior criminal history. Again, where is the connection? What does that have to do with what happened on June 4th of 2008? The same can be said for her being a good friend to whom? And how is that important to what happened on June 4th of 2008? Additionally, there's this indication that somehow she lacks support for her family. As you saw here today, and as you've seen throughout these proceedings and from the defendant's own mouth, that she indicated that her mother was here. That's an indication of support. But even though there was or there wasn't support, there's nothing to do with the killing. She talks about having suffered abuse and neglect as a child and as an adult. Again, where is the connection? And the fact that she's trying to better herself or that she is trying to do the best in her life, again, what does that have to do? And that she's a good artist, again, what does that have to do with the murder? There's another aspect of these that we need to talk about, and specifically, these are not mitigating circumstances.
Objection, it's a lot.
Yeah.
With regard to these, number 2, they indicate to you that the defendant has no criminal history. Really? Were you present when she was testifying? Do you remember her testifying? And do you remember her testimony that she was untruthful to you?
Objection, Your Honor, mischaracterized as a testimony, it's argumentative.
As stated, sustained.
Do you remember the colloquy involving the gas cans? Do you remember what she told you about that? And she took an oath to tell the truth, the whole truth, and nothing but the truth. When somebody takes a stand and they are not being truthful, that is a crime. True, she hasn't been convicted of it, but does that mean that she has no prior criminal history? That happened before this, and that is something for your consideration. And that is a microcosmic, if you will, view of the rest of these mitigating circumstances as they are laid out. That she was 27 years old. Evidence has been presented that she has gone through 4 boyfriends, that she has gone through numerous jobs.
Objection, argumentative.
Overruled.
That she, according to them, there's going to be evidence that's going to be presented that she was a good caretaker of Mr. Brewer's child, that she had a good relationship with him. So in those 27 years, she has lived a lot. It's not like she was an 18, 19-year-old child that had never been out in the world. Additionally, that she was a good friend. Good friend to whom? That apparently to this individual that will come in and testify to you that she has been a good friend to the defendant. What does that mean? When was she a good friend? And how does that make this a mitigating circumstance? That she lacked support from her family. You saw her mother here. How do we know, other than from the defendant's mouth, that she lacked support from her family? And remember, you keep in mind the previous 2 other proceedings, including the guilt phase, where perhaps when she was speaking to you, there were those inconsistencies and those issues with her speaking to you. That she suffered abuse and neglect as a child and as an adult. That is something that has been gone over many times on the witness stand during her 18 days that she was up there. And during that time, as you know, no evidence was presented from any medical facility, from a police agency, and from anybody else that would support that, just the defendant's word. That she's trying to make the best of her life and is trying to improve herself. Well, isn't that just what everybody tries to do? Isn't that just normal? Isn't that something that most people do? Why is that a mitigating circumstance? And finally, something about her being a talented artist. And you've heard that as a talented artist, she somehow was somebody that could, you were told about paintings. You were also been told from the witness stand that she's a photographer. Yes, I guess in a way she is a talented artist because she can take photographs of Mr. Alexander in the shower that look like the Calvin Klein commercial. And after she takes pictures of him in that position, and after there are inadvertent photographs of her committing this crime, do we know? That she's so talented that she can take that camera and delete the images that negatively affect her.
Facts not to be considered.
The fact that she's that talented indicates in this particular case, that all of these items that have been presented to you, every single one of them, is nothing more than the defendant's statements attempting to gain sympathy. And in view of the fact that there are no mitigating circumstances in this case, the only appropriate sentence based on what the jury instructions tell you that you should do is death. Thank you.
Ladies and gentlemen, please go back to the jury room for approximately 5 minutes. You will be recalled at that time. Please be seated. The record will show the presence of the jury, the defendant, and all counsel.
Flores is like, oh God.
Ladies and
I'm finally
gentlemen,
gonna
at
get
this
to go.
time, victim impact statements will be read to you. Mr. Martinez?
Statements for admission exhibit 656 through 661.
Counsel, please approach. You may proceed.
The state requests that Stephen Alexander address the jury.
Mr. Alexander, please come forward.
My name is Stephen Alexander. Travis was my big brother. I was sleeping in after working a 12-hour graveyard shift in the Army. I woke up to the sound of my wife crying, walking up the stairs. I will never forget what she said. Samantha, I cannot tell him. You have to. My wife handed the phone to me. It was my sister, Samantha. She was crying hysterically. She told me, Stephen, Travis is dead. I thought I was dreaming. She didn't really have any details at the time, so I just gave the phone back to my wife. A few moments later, we found out he was killed. I remember walking out my back door, screaming, crying at the sky, asking why. Then I sank down into a corner and I cried some more. A while later, my commander called with the same news. I kept my composure, but in my head, I was reliving the same exact moment all over again. As soon as we hung up, I broke down again. I thought my brother was bulletproof. I thought he was stronger than anything. He couldn't be cut down or knocked down. He was in 2 motorcycle crashes and walked away unharmed. He wrecked several cars and nothing happened to him. He rolled a snowmobile and again, not a scratch. He was unbreakable. Who on earth would want to do this to him? For what reasons? He wanted to move forward in life, to better himself and only to help others. Why him? Unfortunately, I won't ever get the answers to most of my questions about my brother's death. Questions like, how much did he suffer? How much did he scream? What was he saying? What was the last thing he saw? before his eyes closed. What was his final thought in his head? The last time I saw my brother was Christmas of 2007. We had a really good time. A lot of our family was there. We played a bunch of family games. One in particular was the American Idol game. Travis kept beating everybody. The only way I can actually beat him was by singing a Kelly Clarkson song in a girl voice so I can hit all the notes.
Judge, if I may show Exhibit 656.
We had nicknames for each other, Stevis and Travhead. So he said, Stevis, it doesn't count because it's a girl song. I tend to disagree. He got to meet my daughter and hold her for the first time.
You don't get to cry, ma'am.
He said, she was the most beautiful little girl he's ever seen. I never would have thought that would be the last time that I would see him. The nature of my brother's murder has had a major impact on me. It's even invaded my dreams. I have nightmares about somebody coming at me with a knife and then going after my wife and my daughter. When I wake up, I cannot establish what is real, what is a dream. I've even gone through the house searching through rooms, shaking my family to wake them up to make sure that they are alive. My wife has woken me up out of nightmares because I was screaming in my sleep. It may sound childish, but I cannot sleep alone in the dark anymore. I've had dreams of my brother all curled up in the shower, thrown in there, left to rot for days, all alone. I don't want these nightmares anymore. I don't want to have to see my brother's murderer anymore. I don't want to hear his name dragged through the mud anymore. I've been hospitalized several times for ulcers and came very near to death. I've been on several different antidepressants. Unfortunately, none of them really worked. I wasn't able to be the husband my wife deserved. I distanced myself from everybody. My wife and I we separated 2 years ago. And it was for a period of 2 years. My poor little girl had to be passed back and forth every week. And now, yet again, I have to be away from my wife and my child. It has been over 4 months now. I go home to California during the weekends. Every time I have to come back to Arizona, I see my little girl cry and beg me not to go. I miss them very much, and I cannot wait for this to end so that we can all get back to our lives. Travis used to write out his day on a flashcard. The last one he wrote said to call Stephen. I never got that call. He had been concerned about my health and wanted to fly me to his house and help me quit smoking. I never got to go. Now, when I want to talk or see my brother, I have to go to a 3.5 foot, 8 foot long, and 6 foot deep hole in the ground. He was meant to do so much more. He never got to live his dreams. He never got to meet his goals. In 2008, he wrote his affirmations on his blog. This year will be the best year of my life. This is the year that will eclipse all others. I will earn more, learn more, travel more, serve more, love more, give more, and be more than all the other years of my life combined. True, other years now past have been at times magnificent, but not like this. This is a year of metamorphosis, of growth and accomplishment that at previous times was unimaginable. A year where the impossible will become commonplace and the unachievable will become effortlessly achieved. Where I raise myself to heights only visited by the great men and women of this world by so doing this year will be the best year of my life. And how will I do this? Through compassionate service, random acts of kindness, unconditional love, and acknowledgement of the true source of all blessings with gratitude in my heart. And when I fail, I will learn from my mistakes. I will strengthen my resolve, be better than I was before. What will I do to improve my finances? I will work harder, yes, but more importantly, I will work smarter and learn to leverage myself and get more out of one day than I previously got out of a month. I will succeed through integrity and through the selfless service of others. Through the powerful forces and the structure of the mind, I will tap into the source of infinite intelligence and be more efficient in all my endeavors and be an exponentially greater asset to this world. I will love and then love more. I will serve and serve more. I will forgive and then forgive more. I will not let these thoughts fade, but instead remind myself of them daily and spend time visualizing myself in accomplishment of them until the day that my thoughts become reality. Then I will not stop, but press forward to new goals and new heights in my quest to change this world. I will be a published author, and effortlessly doing so what I was meant to do to better my life and the lives of others. I will associate with more successfully minded people to be a teacher as well as a student. I will travel this great country and this great planet, gaining rich experiences founded by very few. I will find an eternal companion that enhances me exponentially, and countless other goals that at one point I dared not even dream. 2008 will be the best year of my life, which will lay the foreground for 2009 to dwarf the accomplishments of 2008. This year will be the best year of my life, and I will succeed. I know Travis only hoped to change one life. He never would have thought he could change the world. People across the globe have been influenced by him. Travis believed every single one of us was created to be successful. We all have different lives and trials. We just have to get there. Travis has a legacy. It is up to us to make sure it survives. You were born to be great. It is your destiny. The difference between a stumbling block and a stepping stone is the character of the individual walking the path. Travis coined that philosophy. Those are Travis's words. That is the way my brother lived his life. That is the way he wanted to continue to live. That is how he wanted us to live. he will never get to do that because he was so brutally ripped out of this world, my world. Hopefully one day I can make him proud. Thank you.
Mr. Martinez.
Next is Samantha Alexander.
Ms. Alexander, please come forward.
My name is Samantha Alexander. I am one of Travis's younger sisters. There are 8 siblings, 4 boys, 4 girls, and this tragedy has forever changed our lives. I'm going to do the best to speak on behalf of my family. My family that has been tortured by the loss of our beloved brother and family member. From a family of 8 siblings, we have always been there for each other, through the good times and the bad. We lost our father on Travis's 20th birthday, and our mother shortly after. And through this trying time in our lives, Travis was the one that got us through the pain and the hardship, because he was our strength.
Exhibit 659.
This is a picture of my grandmother. She is the one that raised Travis. My grandmother could not deal with loss, could not handle the reality of what happened. Travis being taken from us has put her over the edge, and her health eventually went into a downward spiral she never recovered from. Losing Travis has completely destroyed the overall health of our family. We lived a blessed life with our grandmother, and it was with insurmountable pain when our grandmother died shortly before jury selection of this trial. Travis was our strength, our constant beacon of hope, our motivation. And his presence has been ripped from our lives. His giving spirit, his determination for accomplishment, and his endless strength as the foundation of our family has been taken from us and never can be replaced. Something that we have all missed and will live the rest of our lives missing are our times together, especially during the holidays. Travis always gave us motivational books which are about saving the planet, 1,000 places to see before you die. It is sickening to think that he motivated us with topics he will never be allowed to live out. It's not just the holidays. But every day will never be the same. Our lives will never, ever be the same. Travis worked hard for everything he had. He never had any handouts. He never took anything for granted. Travis was not shy. He was full of life. If he were able to walk in this room, you would immediately feel his love and warmth. Travis would cry with you. He would laugh with you. He would joke with you, always lifting your spirits. Travis's greatest attributes were his ability to make others feel appreciated, accepted, and loved because he genuinely cared about making those around him feel good about themselves. His mission in Colorado is a testament to this, as was volunteering to help the homeless by driving around in his Toyota Prius with our sister Tanisha, handing out care packages to the less fortunate, providing essential hygiene products, food items, and personalized message that he wrote on the brown paper bag that held his gift. He wrote, "The difference between a stumbling block and a stepping stone is the character of the individual walking the path." You see, Travis wasn't anything but a loving brother, son, grandson, and friend. He was our strength and our motivation to make our lives better than the ones we were born into. This is exactly why Travis was such an accomplished motivational speaker. It saddens and sickens us all that his potential was cut short, and our family and the world will never receive the full benefit of his goodness. Towards the end of May 2008, just a couple weeks before Travis was killed, he came to visit me at my house in Southern California. He was so excited to let me read his intro to the book he was writing, a motivational book titled Raising You. Travis and I got into a deep conversation about our lives, our crazy childhood, our cockroach phobia. We both agreed no matter how miserable our lives were at times, our childhood is what made us who we are. Our childhood made us strong and able to conquer anything. This was the last time I saw Travis.
Exhibit number 660.
He talked me into taking this picture even though I was in PJs. It makes me cry every time I look at it. I'm so glad he talked me into taking this picture. I will cherish it for the rest of my life. Recalling the moment that I found out about my brother's death, I think of my ears ringing, my stomach burning, and this idea that this can't possibly be happening. On the morning of June 10th, 2008, I was on a river trip in Parker, Arizona. We were getting ready to take the boat out. I checked my voicemail before we went out for the day. There was a message from my grandmother. My heart sank into my stomach. She said, "Samantha, you need to call me back. It's very important." I could tell that she was crying, and I recognized her tone of voice from before. I knew that someone was dead. I called my grandma's house, and my sister Tanisha answered the phone. She screamed at me. She said, "Samantha, Travis is dead." I could barely breathe out the words, "What happened to him?" She told me that no one knew and the police didn't provide any details. To this day, my mind paints a picture of what happened the night Travis was taken. even though I try not to let it. Upon standing in the same exact spot where this horrific tragedy happened, when we had to go to Travis's house after the investigators were done, I felt the same sickening feeling. My ears ringing, burning stomach. My eyes were filled with tears to where I could barely see. The thoughts of what Travis must have went through that day. The pain, the agony, the screams and fear that Travis must have felt when he was brutally being taken. We have been at this trial every day since it started. We have heard every detail about the crime and the injuries Travis suffered. I am a police officer, and some of these photos are more gruesome than I've ever seen in my 11 years of law enforcement. Our minds are permanently stained with the images of our poor brother's throat slit from ear to ear. Our minds are stained with the image of Travis's body slumped dead in the shower. Our family has bore the burden of extreme loss and financial hardship to be here to see that Travis is not forgotten and to ensure that his life was not lost in vain. From being away from our sons, our daughters, nieces, and nephews, to stepping down from opportunities in the workplace, to suffering from anxiety and severe depression, requiring many, like my grandmother, to submit to antidepressants and anxiety medication. Travis was the only family member that lived in Arizona, making it very difficult for us to be here. We have paid the ultimate price losing Travis. Each and every one of us have looked to Travis for support and words of guidance during times like this. None of us ever thought that he wouldn't be here when we needed him the most. To think that someone so loving, so caring, so giving could be taken from us, given the already tragic lives that we have lived. But to have Travis taken so barbarically is beyond any words we can find to describe our horrific loss. I cannot adequately express how much we will miss our brother. We will miss his contagious laughter, his singing voicemails, his jokes, his funny dances, his help in hard situations, his guidance when we are lost, his motivation, his insight, his huge smile.
Exhibit 661.
Him being there on the holidays. Travis was the glue in our family. Our family has not been together since Travis has been gone. It's simply too hard to think of that one empty chair. We miss his charisma, his goal to make someone feel good about themselves and to make someone smile, no matter who they are or what they look like. Travis had an incredible heart. He had a huge heart. And it was this huge heart and his kindness that will forever be missed. We were robbed of so many good memories, so many awesome moments with Travis. Our lives will never be the same. We can never get him back. We are so grateful for our wonderful brother, and we feel so lucky and blessed for the time we had with Travis, however short-lived. We would give anything to have him back. Anything. Thank you.
No one else, thank you.
The record will show the presence of the defendant and all counsel. The court has received a motion for mistrial for the sentencing phase and an objection to the motion for mistrial sentencing phase. Mr. Nurmi, you wanted these motions heard in open court. Do you have additional argument?
I do, Your Honor. I think the backdrop to this motion really begins with two motions that were decided before this trial began on January 2nd. The motion to Ms. Arias' objection to the media coverage to having live camera feed of this trial, as well as her motion to sequester the jury. Both those were denied in the face of case law designed to protect Ms. Arias' rights to a fair trial. We think because those were denied when this trial began on January 2nd of this year, what proceeded from that day on was not a fair trial, was not a trial that comported with the constitutional dictates because of those very reasons. Now, a lot of the reasons of what happened and some of the motions made and the corollaries to those earlier motions were done under seal. So I don't need to revisit those. However, this court had a duty to protect Ms. Arias' right to a fair trial and failed to do so time and time again. Once this trial started, the prosecutor, in violation of State v. Smith, disrespected defense counsel in front of the jury. In violation of In re Zawada, the state attacked expert witnesses in front of the jury with non-evidence designed to mislead the jury regarding the experts, attacking the messenger, not the message.
You can't handle the
Ms. Arias
truth.
asked for mistrial at several points in time to do these clear violations, and this court ignored it.
Well, isn't that
And
special?
between all these things that were going on, all in violation of Ms. Arias' rights, we have the issue of witness intimidation. Witness intimidation began almost the very day that Ms. Arias started a case, or at least those days when Ms. Arias wasn't on the stand.
That is the face of somebody who's
Ms.
not
Arias made her
buying
record
this.
in that regard, and nothing was done. Now we're in a position where the intimidation continues. I have filed some exhibits. I asked, contemporaneous with this motion, I asked that they be filed under seal regarding the intimidation of Ms. Womack. The intimidation of Ms. Lila Violet has been documented under seal. Now we're in a situation, Judge, where a key mitigation witness, someone who knew Ms. Arias long before Mr. Alexander came along and came into her life, has been intimidated, and you can see from the letter, who feels that her life is being threatened to a point where she cannot come forward and testify on Ms. Arias' behalf. This is constitutionally unacceptable under Lockett and Eddings and the case law that we've laid before it. As I said in the motion, this court now, this is far from a trial that comports with constitutional realities. This cannot be a modern day version of days gone by of stoning or of witch trials. This court has a duty to Ms. Arias, convicted of first-degree murder or not, to make sure that the mitigation phase, the sentencing phase, comports with these dictates. And there's pretty clear case law that this is unequivocal. In response, the state argues facts that aren't quite correct regarding Ms. Womack and her answers to the questions, her choice not to answer certain questions, which she has a right to do, by the way. But that is irrespective of Eddings and that line of case law related to her, Ms. Arias' right to present a full mitigation case, to give the jury a full picture of her life. The intimidation of Ms. Womack and Ms. LaViolette to some degree, as we've made ex parte, is evidence that this picture is not complete. A partial picture is not good enough for this jury. It just isn't. And this court then, because of this, and the state decided no case law to support their position that a mistrial shouldn't be granted. And that's because there is none. Because there is, in the face of the state's position, or in the face of any contrarian position, is well-established precedent in case law. That Ms. Arias has the right to present this full picture. She's being precluded from doing so, and therefore a mistrial at this stage of the proceedings is the only lawful remedy.
Mr. Martinez.
The issue before the court today involves Patricia Womack. It doesn't involve the court's hearings previously. And I know the counsel at every turn has attempted to chastise anyone who is near the defendant or somehow feels is to blame. He now chastises the court. And as part of that, he also chastises the prosecutor. The state believes that those comments are not well taken. The issue here is why Ms. Womack is not here to testify. As the court has been informed, on May 15th of 2013, I conducted an interview with Ms. Womack. On 2 separate occasions, she failed to answer my questions. Specifically, the first occasion occurred when I started to talk about her drug use as it involved the witness and the defendant. At that point, she deferred and chose not to answer. Rather than end the interview at that time, I chose to continue and seek whatever it was that she had to say. At one point, when she was asked about photographs of herself and the defendant, she started to equivocate. And at that point, she asked or indicated that she wanted to leave the room. She left the room in the company of Jennifer Wilmot and Kirk Nurmi, people that are not her attorneys, people who have an ethical obligation to Jodi Arias not to advise another witness such as Patricia Womack. Patricia Womack and the 2 attorneys were gone for a short period of time. When they returned, the lawyers attempted to assert her Fifth Amendment rights to remain silent. That would be Patricia Womack's rights to remain silent. I deferred on or demurred on that and asked her directly whether it was her desire, not the lawyer's desire, to assert her Fifth Amendment rights. And she indicated that it was her belief that she should assert her Fifth Amendment rights. There are many issues that are involved with this witness, and not the least of which is that she faces some prosecution, for lack of a better term, involving those photographs. We don't need to get into the detail of it because it is clear that she didn't report that income, and that would subject her to criminal penalties. Additionally, the use of illicit drugs, again, may or may not subject her to criminal penalties depending on her status in California. It is clear that she had some sort of substance abuse problem, and that's something that would have been addressed at trial while she testified. So this individual that they claim received threats came to court and that Thursday, which would have been the 16th, and at that time the court appointed Kenneth Countryman to assist her in determining whether or not she should assert her rights. At that time, Mr. Countryman indicated that he could not make an assessment and wanted to wait till Monday. It's interesting to see that the record as presented by defense counsel, or the facts as presented by defense counsel, are silent as to whether or not Ms. Womack would have heeded her attorney's advice on Monday the same way that she did on Thursday. It is the state's belief, based on that silence, that she would have asserted her Fifth Amendment rights. And that being the case, she would have been precluded from testifying. So it's easy to point fingers. It's easy to say that there is no case law that is being cited. It's easy to say that because the facts indicate that this individual, if she were to call to testify on advice of counsel, would not have testified. I do have, for the record, and I do want to make it part of the record, a copy of the interview that took place between the prosecutor and this witness on May 15th, 2013. It bears out the prosecutor's version of events how she did, in fact, fail to respond to the first question involving drug use, and then she invoked her Fifth Amendment rights after conferring with counsel, not her counsel, Mr. Nurmi and Ms. Wilmot. She invoked her Fifth Amendment rights, and she is not here. I do not see Mr. Countryman, so I suspect that based on that silence, that she again would choose to invoke her rights, making this issue of whether or not there were any threats viable. It's an issue that can't be reached if she's not going to testify to start with anyway. So if I may mark this and have it included as part of the record.
The exhibit will be made part of the record and sealed along with exhibits 663, 662, 663, 664, and 665.
And clearly the motion for this trial based on the facts is not warranted, and I ask you to deny that request.
Mr. Nurmi, anything else?
Yes, Your Honor, like much of what the state says, the truth doesn't associate with what it's saying. It's just simply not true. We never advised Ms. Womack to do any particular thing. She was appointed counsel. That's what she was brought here to do with Mr. Countryman. So, and the rest of the bluster that Mr. Martinez is saying to try to divert you from the reality has nothing to do with the issue the court must decide. You know, he wants to disparage her for drug use, that sort of thing. And that's exactly what we're talking about here when I brought up Smith and when I brought up Zavada. When you have a prosecutor, when this court allows a prosecutor to personally attack witnesses and counsel, that breeds an environment where this sort of thing is endorsed. And that's exactly what has happened throughout this trial with the intimidation. The other issue, and the other argument the state makes, well, she would have pled her Fifth Amendment rights anyway, therefore this doesn't matter that she got threats. Well, we don't know whether that's true or not. It's just based on the state's speculation. But let's say it were true. If she were to plead the Fifth and not be available, the picture would still be incomplete. The reasons would be different, but the effect on Ms. Arias would be the same. You see, he can cast aspersions all he wants on every witness, I guess, on his own, but he's not allowed to endorse, this court is not allowed to endorse that, and it's not allowed to endorse it, especially in the face of a system in which she is afforded certain rights at the sentencing phase. The right to present a full and complete mitigation case. That right has been ripped away from her. Thus, a mistrial, again, as I said before, is the only lawful remedy at this point.
All right, the court finds the defense has failed to establish that the sentencing phase cannot go forward and that the defendant cannot receive a fair trial in that sentencing phase. There are issues which have been raised in proceedings outside the courtroom. Those proceedings were sealed at the request of defense counsel. I am not going to review this court's decisions with regard to those sealed matters. However, this court has indicated to defense counsel that any witness they wish to call for purposes of the sentencing phase could be called in a sealed proceeding, and this court would seal those proceedings. That should address any concerns about intimidation or threats as set forth in the defendant's motion. This court can only speculate as to why Ms. Womack is not here today. Similarly, this court could only speculate as to the absence of other possible witnesses for purposes of the sentencing phase. Without more information, this court finds there is no basis to grant a mistrial, so the motion for mistrial is denied. Mr. Nurmi.
Ms. Wilmot and I would move to withdraw from the case yet again. Under Strickland v. Washington, we are in a position where we cannot provide effective assistance to counsel at this phase of the proceedings. We cannot present the complete picture that is incumbent upon us. Rule 6.8 as well, Arizona Rules of Criminal Procedure, imposes that duty upon us as well. We cannot fulfill that duty because we cannot provide the picture. There is no speculation as to why Ms. Womack should be here. She feels threatened, she feels intimidated, and she doesn't feel like she can be here. So that being said, under Strickland, Ms. Wilmot and I cannot meet that standard and then move to withdraw.
Your motion to withdraw is denied. All right. Are we ready to proceed with the
Denied.
jury?
Your Honor, we will not be calling witnesses in the face, given the court's ruling and the incomplete picture. We will not be calling witnesses in the defense case.
All right. I assume your client
All right.
does wish to allocute.
Spicy.
We approach.
You may.
Oh, not anymore.
Show the presence of the defendant and all counsel. The court did
He did 4 times.
meet in chambers ex parte, sealed proceeding with the defendant and counsel. Based upon information provided during that sealed proceeding, the court is going to adjourn for today, and allocution will occur tomorrow morning at 9:30. In addition, I did not address one of the requests in the defendant's motion regarding providing a statement to the jury regarding the reason Ms. Womack is not testifying during the penalty phase. Does the state wish to be heard?
I've indicated in my response that it would be improper since we really don't know the reason why she failed to show up and why she fails to want to testify. Additionally, my information, which I would have asked of her on the witness stand, would have been as to whether or not she believed or was in favor of testifying in this particular case, because she believed that the defendant had a bad background, or so to speak, and she would have indicated that she believed that the defendant had a very good background growing up, and that she did not believe that there was anything in her background that would have called for leniency.
I think this is Jodi's friend.
Mr. Nermi?
Well, I'm not sure where those supposed facts came from, but be that as it may, Judge, I think we have consistent with the mistrial motion. I know this court has denied, but at the time opening statements were made in this phase, we believed and the jury was advised that they would be presented with these witnesses. Now they're being presented with none. One of the exhibits shows the exact reason why Ms. Womack is not present. So we believe such an instruction would be appropriate.
Again, the court is aware of a number of reasons Ms. Womack may not be present. I will read to the jury a modified statement. I will indicate she is unavailable, but I will not read the last sentence of the requested instruction regarding Ms. Womack. All right, is there anything else?
Yes, Judge, the other thing we'd be asking for, consistent with this court's ruling on both aspects of the motion for mistrial, the sentencing phase, we'd be asking a stay of these proceedings so we could seek special action relief.
Motion for stay is denied. All right, is there anything else for today?
If we may approach.
You may. Please be seated. The record will show the presence of the jury, the defendant, and all counsel. Good morning, ladies and gentlemen. We are unable to proceed today. Please return tomorrow morning at 9:30. Please remember the admonition. You are excused.
Okay. Good timing. Thanks, Judge. All right. So this is like literally the last video. Woohoo. All right. So there was questions as to what the heck was happening. A former friend of Jodi Arias, who was supposed to testify on her behalf, was not testifying all of a sudden. Kirk said that it was because of threats on her life, as if she were to testify. Kirk also said that Womack notified the defense Sunday that the threats had influenced her decision not to testify. And yes, I am reading an article because I wasn't entirely sure either, and you deserve the best information. Apparently, she's not the first defense witness to be harassed and receive death threats. Dr. Richard Samuels also received threatening communications. Elise LaViolette was also threatened. So yeah, they had planned to call 2 people to testify on behalf of Arias Womack and Daryl Brewer, who was Arias's ex-boyfriend. But I don't think Brewer was going to. I don't think Brewer's testifying either. So that's what happened. And Juan was saying that he was going to cross her and totally reject everything that she said because it wasn't true. And yeah, so woof, haha. Here we are.
And the testimony of Patricia Womack. Ms. Womack was supposed to testify regarding the abusive environment Ms. Arias grew up in, as well as the abuse she suffered as an adult. Ms. Womack is unavailable to testify. Ladies and gentlemen, the defendant will now speak to you. This statement is not made under oath and is not subject to cross-examination. Ms. Arias,
And is
you may
not
proceed.
truthful. Everybody get your gavels out, your whack-a-moles, because that's going to be required.
You may proceed.
You, David. Your Honor, I object. Objection.
Well, man!
Some months back, while the first phase of this trial was ongoing, my mom visited me just like she'd been doing every week since trial began. She told me that after leaving the courthouse, she was idling at a stoplight and she happened to look over at the car next to her. And Travis's siblings were in that car. My mom and I were silent for a few moments when she finally voiced exactly what I was thinking.
Nope.
She said, I know they're going through hell.
Could it be?
Yet nothing drove that point home for me more than when I heard them speak last week. I never meant to cause them so much pain. When Stephen said he read on Travis's 3x5 card that it said call Stephen and that he never got that call, I know that's because of me. And when Samantha showed us the last picture that she took with Travis, I know it's because of me that will always be the last picture that she'll ever take with Travis. Throughout this trial, I've avoided looking at Travis's family for a variety of reasons that I won't go into.
That's not true.
But I've wondered, where is his grandma? Is she here? I didn't learn until last week what happened to her.
Boo-hoo.
Samantha said that Travis was the glue to their family. Around Thanksgiving not last year, in 2007, Travis called me.
Yada, yada, yada. Blah,
He said his
blah,
grandmother
blah,
was
blah,
ill
blah.
and frail, and that he didn't know if she was going to make it. He said he didn't know what his family would do if she didn't make it because she was the glue to their family. To know now that both are gone and that I may have also inadvertently induced her passing destroys me. Every time I've had the thought or desire to commit suicide, there's one element that has almost always caused me to waver. They're sitting right over there. They're my family. At times, I've lost track of that element. For example, the incident I testified to when I took my razor apart at the Siskiyou County Jail. I managed to convince myself that we would get over the pain with time, and that in the long run, I was doing them a favor by unburdening them of my presence in their lives. I wrote a bunch of them goodbye letters, addressed specifically to each person, and in the letters, I didn't focus so much on explanations, but on how much and why I loved each of them. Then I wrote a general explanatory letter to help them understand my decision. At that time, I saw it as taking myself off of life support. I didn't know a lot of anything about prison at that time, and I didn't think it was fair to expect my family to have to support me for the rest of my life. I didn't know then that if I got life instead of death, I could become employed and self-reliant. I didn't know that if I got life, there are many things I can do to affect positive change and contribute in a meaningful way.
Even before you start. That was a preemptive.
In prison, there are programs I
Just
can
know I have
start
a whole bag of
and people I can help,
with your name on it.
and programs that I can continue to participate in. I'll share a few examples that I thought of.
This
few months
speech
before
is
trial,
written
And by that I mean jury
like
selection.
an 8th grader.
My hair was past my waist,
Oh.
and I donated it to Locks of Love, the nonprofit which creates wigs for cancer patients who lost their hair. In fact, that was my 3rd donation to that organization since I was arrested. If I'm allowed to live in prison, I will continue to donate to that organization for the rest of my life. Over the years I've spent in incarceration, I've received many requests from women to teach them Spanish or American Sign Language. Because my case was pending, I just didn't have the time. In prison, I will. If I'm sentenced to life, I will live among the general population of women, and I'll be able to share my knowledge of those subjects with them, the ones who have the desire to learn also. I may even be able to start classes. If I get permission, I'd like to implement a recycling program. The women's prison in Goodyear houses thousands of women, and each week, huge loads of waste are hauled off to a landfill. A substantial portion of that could be kept out of landfill and recycled instead. It may even create new jobs for the people there. This is one small thing that could have a far-reaching and positive impact on the community and on the planet. There's a higher rate of illiteracy in prison than in everyday society. I know that reading has enriched my life by expanding my knowledge base and opening my eyes to new worlds and different cultures. I can help other women become literate so that they too can add that dimension to their lives. Along the lines of literacy, I'd like to start a book club or a reading group, something that brings people together in a positive and constructive way so that we can share and recommend other good books and stimulate discussions of a higher nature. Additionally, I've designed a t-shirt. This is the t-shirt.
Oh, there it is.
Of which 100% of the proceeds go to support nonprofit organizations which also assist other victims of domestic violence. Some people may not believe that I am a survivor of domestic violence. They're entitled to their opinion. I'm supporting this cause because it's very, very important to me.
I mean, you're a survivor, but
These
you
are only a
did
handful of examples. I've never been
You're
to
on the
prison.
giving side.
I don't know from personal experience what it's like there. But I'm certain that after I arrive, I'll likely find many other ways in which I can contribute to the women there. I'd like to share with you now a few things about me and a few things about my family.
Oh, she got the presenter thing out. I'm gonna feel
When I
self-important.
was little, my mom took a lot of pictures of me. I'm her first child. She had her camera everywhere and she would take a lot of pictures of me when I was first born. Salinas is near the coast, and so it seemed a lot of overcast days, but when it was sunny, she would take me out to the backyard and turn on the sprinkler so I could play. That's me attempting to dress myself. A few years later, Carl
She
came
had
along,
to get that
my
last
little brother.
hurrah where all the
We
eyes
became
were on her
inseparable.
before she went away forever.
When we were little, my parents took us everywhere, including SeaWorld here and Hawaii. But my fondest memories with him are of us
These
scooping
girls
off
get
at
some
home on a
Canva.
lazy Saturday, just making a mess of the living room in our pajamas. When I was 11 years old, and the slide is backward, I apologize. When I was 11 years old, my little sister, Angela, was born 4 weeks early.
Be
We
quiet.
called Slinky here.
You
I
are a
was so
meat.
excited to have a baby sister. I
Oh!
watched my mom's stomach grow. I watched Angela come into this world. And after the doctor swaddled her, he turned to me and said to my mom and said, "Do you want to hold her first?"
Stupid idiot.
These are various school pictures. And on occasion, my family and I would get together for family portraits, such as these. In 9th grade, my family and I moved back to Wairika,
Make
but
her
I
away
still
from
went
that
back to
slide
Santa
real
Maria
fast.
periodically to visit friends. This is Patty. She was my best friend for years. She was here last week to testify on my behalf, as you heard Mr. Nermi tell you in opening statements. But she didn't return today because she and her 9-year-old daughter were threatened and harassed if she came back to this state. I'm 21 years old here. After I moved out of my parents' house at age 17, my relationship with my dad improved a little.
I was
This is my
born
grandma,
on a dark,
twins.
dismal
My aunt's on the left
night,
and my mom's on the right.
and my life was just as
These are my
dismal.
parents when they were just a little bit younger. This is Bobby and I. It's a little out of order chronologically. We're hanging out in our dirty little rundown house in Montague that I had mentioned previously.
So she
At
killed
times we lived there
Travis,
without power and phone.
and with
The
their
winters were
family
freezing, we
there,
see our
she's
breath
showing her
inside the house.
boyfriends of
My
life
parents did not
past.
support this relationship. And we were young and just trying to figure
Your
out why.
mother was a hamster, and your father
When
smelled
this
of
picture,
elderberry.
when I see this picture, I'm reminded of that quote by Charles Dickens when he says, "They were the best of times, they were the worst of times." We're smiling here, and this picture to me signifies that. It was a difficult relationship, but Bobby will always be special to me. I'm 21 here. This is a photo of Matt McCartney and I, taken a few months after we broke up, a few months after he moved down to Big Sur where I was working at Ventana. As you know, we remained friends, and on this day we utilized Ventana's company passes to tour the Monterey Aquarium. Daryl and I began seeing each other a little over a year after that. In this photo, I'm coming out of a redheaded stage that I went through for a few years. This is one of my favorite pictures of Daryl and me. We were at Chivo's, a restaurant in Monterey, where our friend Tony and his band were playing blues and reggae live. He dedicated songs to us and danced. Daryl was a good dancer. When we began dating, we started a yearly tradition in which we'd go camping every summer at this remote little campground. It's called Kirk Creek. It's south of Big Sur, in an area that the locals call the South Coast. This is Daryl, Jack, and I at Ventana. It's hard to see in this photo, but the ocean is in the background. It's on the terrace.
Unnecessary details
Home
here.
desert, we sought out some snow in the nearby mountains that first winter. We settled in and made a little life for ourselves for that spend time. Jack was always with us on the weekends. He took that picture of me. I made friends with my coworkers, and sometimes we'd go out after a shift just to chill and hang out. Daryl and Jack and I did a lot of things together. Here we rode the aerial tram in Palm Springs to the top of the San Jacinto Mountains. Daryl's ex-wife took this picture. We were all at Chuck E. Cheese's celebrating Jack's 7th birthday. Jack and I bonded. He's a great kid. I haven't seen him since June 3rd, 2008. I hear he's much bigger now, taller than me. My family and I still got together periodically for group portraits. These were taken at a park in Mariga. In 2010, my little sister gave birth to this beautiful little girl on the right. The tiny premature baby that I've witnessed come into this world now has a baby of her own. She's a mature, responsible, dedicated mother. She's also engaged to a wonderful man. And his daughter, this gorgeous girl on the left, is my niece's new big sister. I've met these girls only through a thick pane of glass. They get along like they've always known each other.
That's
Oh,
what
yeah, my
happens when
sister's
you
wedding.
unalive somebody.
When she ties the knot next year. And I won't be her wedding photographer like we had always talked about. The same is true for my brother Carl. The boy I grew up with became a family man. He and his wife married in 2010. I wasn't there to celebrate with them, and I wasn't there to take their pictures, and I have no one to blame but myself. A few weeks before trial, they welcomed this precious little baby into the world. I haven't met her yet. Until a few weeks ago, I had huge hopes of becoming a part of these girls' lives someday. My nieces are the closest I'll ever come to motherhood, because I'm not going to have children of my own.
She sang
I'm
to
not
them.
going to become a mother. Because of my own terrible choices, I've had to lay that dream to rest. You've heard before that I'm an artist. As it now stands, I'll never create another oil painting. But these are some of my drawings. I'm pretty good with hands and nature.
I'm pretty good with hands.
And nested portraits.
Oh, don't do that to Frank. Oh, Elvis.
This picture is a little distorted. This is my niece when she was a bit younger, playing the piano.
No, Jodi, no. This is not show and tell. This is not an any old bag speech, Jodi.
My family and I have a lot of memories, especially ones like this at Christmas. We won't be creating any more of these kinds of memories together. This is how I used to spend the holidays with my family. It was Carl's idea to hold my portrait in this Christmas family photo taken a few years ago. My parents were there, my siblings were there, my brother's wife was there. From now on, this is how my family is going to spend the holidays with me. Following my arrest, I wanted so much to avoid trial. Not necessarily the outcome, although that's naturally not something I was looking forward to. But trial. All of the graphic, mortifying, horrific details paraded out into a public arena. Instead, I was hoping
And
to
so
go
she lied to get to trial.
quietly into the night, whether off to prison or the next life.
And there was much rejoicing.
But with the amount of attention my case received early on, I felt in my ignorance that it was necessary to speak out. I got on TV and I lied. I lied about what I did, and I lied about the nature of my relationship with Travis. It's never been my intention to malign his name or character. In fact, it was a goal of mine to preserve his reputation. I didn't want to drag out Travis's skeletons or mine and explain my experiences with them. I didn't want to unveil all of those ugly text messages and emails and that awful tape. All these things which now stand as a public and permanent testimony of the darker aspects of our relationship. To 18 strangers, in front of Travis's family, in front of my family, in front of what feels like the whole world. It's never been my intention to throw mud on Travis's name. When I took the stand, I was obligated to answer the questions posed to me. And if you'll remember, many times I was quick to defend him in the same breath. I loved Travis, and I looked up to him. At one point, he was the world to me. This is the worst mistake of my life. It's the worst thing I've ever done.
I want to talk about me, want to talk about I want to talk about number one on my.
Before that day, I wouldn't even want to harm a spider. I'd gather them up in cups and put them outside. To this day, I can hardly believe I was capable of such violence, but I know that I was. And for that, I'm going to be sorry for the rest of my life.
And there was much rejoicing.
I was horrified by what I'd done, and I'm horrified still.
Game over.
In many ways, my family has also suffered a great loss. Their pain is fresh because they only learned about it 2 weeks ago, the moment the verdict was read. The moment their hopes of ever welcoming me home someday were dashed. My dad, who's here today, was in California, awaiting anxiously in front of the TV. My mom came to visit me after court that dark day. She had spoken to my dad on the way over. And she told me that in the 34 years that they've been together, she's never heard him cry the way he did that day. I've caused that pain. I've caused them to hurt that way. And I will concede that with Travis's family, theirs is a much greater loss, and I can never make up for it. It's my hope that with the verdict you've rendered thus far, that they will finally gain a sense of closure. Stephen said he doesn't want to look at his brother's murderer anymore. If
Now
I
it's
get life,
button
he
on
won't
my
have to.
sound effect board.
I want to talk about me, want
I
to talk
made
about
many public
I want to
statements
talk
that I
about
would prefer the
number
death
one
penalty
on my.
to life in prison. Each time I said that, though I meant it, I lacked perspective. Until very recently, I could not have imagined standing before you all and asking you to give me life. To me, life in prison was the most unappealing outcome I could possibly think of. I thought I I'd rather die. But as I stand here now, I can't in good conscience ask you to sentence me to death because of them. Asking for death is tantamount to suicide. Either way, I'm going to spend the rest of my life in
I don't
prison.
want to get a strike.
It'll either be shortened or not. If it's shortened, the people who will hurt the most are my family. I'm asking you, please, please don't do that to them. I've already hurt them so badly, along with so many other people. I want everyone's healing to begin, and I want everyone's pain to stop. Thank you.
And there was much rejoicing.
Members of the jury, at this phase of the sentencing hearing, you will determine whether the defendant will be sentenced to life imprisonment or death. The law that applies is stated in these instructions, and it is your duty to follow all of them, whether you agree with them or not. You must not single out certain instructions and disregard others. You must not be influenced at any point in these proceedings by conjecture, passion, prejudice, public opinion, or public feeling. You are not to be swayed by mere sympathy not related to the evidence presented during the penalty phase. You must not be influenced by your personal feelings of bias or prejudice for or against the defendant or any person involved in this case on the basis of anyone's race, color, religion, national ancestry, gender, or sexual orientation. Both the state and the defendant have a right to expect that you will consider all the evidence, follow the law, exercise your discretion conscientiously, and reach a just verdict. I do not mean to indicate any opinion on the evidence or what your verdict should be by any ruling or remark that I have made or may make during this penalty phase. I am not allowed to express my feelings in this case, and if I have shown any, you must disregard them. You and you alone are the triers of fact. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a just verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and change your opinion if you become convinced that it is wrong. However, you should not change your honest belief concerning the weight or effect of the evidence solely because of the opinions of your fellow jurors or for the mere purpose of returning a verdict. You are to apply the law to the evidence and this way decide whether the defendant will be sentenced to life imprisonment or death. The evidence you shall consider consists of the testimony and exhibits the court admitted in evidence during all of the three phases of this trial. It is the duty of the court to rule on the admissibility of evidence. You shall not concern yourselves with the reasons for these rulings. You shall disregard questions and exhibits that were withdrawn or to which objections were sustained. Evidence that was admitted for a limited purpose shall not be considered for any other purpose. You shall disregard testimony and exhibits that the court has not admitted or the court has stricken. The lawyers may stipulate certain facts exist. This means both sides agree that evidence exists and is to be considered by you during your deliberations at the conclusion of the trial. You are to treat a stipulation as any other evidence. You are free to accept it or reject it in whole or in part, just as any other evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise observed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence, regardless of whether it is direct or circumstantial. During the aggravation phase of the trial, you found that the state had proved that a statutory aggravating circumstance exists, making the defendant eligible for the death sentence. During this penalty phase, the defendant and the state may present any evidence that is relevant to the determination of whether there is mitigation that is sufficiently substantial to call for a sentence less than death. The state may also present any evidence that demonstrates that the defendant should not be shown leniency. Leniency means a sentence less than death. Mitigating circumstances may be found from any evidence presented during any of the phases of the trial. You should consider all of the evidence without regard to which party presented it. Each party is entitled to consideration of the evidence, whether produced by that party or by another party. You are the sole judges of the credibility of the witnesses and what weight is to be given the testimony of each witness. In considering the testimony of each witness, you may take into account the opportunity and ability of the witness to observe, witness's memory and manner while testifying, any interest, bias, or prejudice the witness may have, the reasonableness of the testimony of the witness considered in light of all the evidence, and any other factors that bear on credibility and weight. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. The attorney's remarks, statements, and arguments are not evidence, but are intended to help you understand the evidence and apply the law. The attorneys are entitled to make any objections that they deem appropriate. These objections should not influence you, and you should make no assumptions because of objections by the attorneys. Relatives of excuse or justification for deliberations in any way must be made in light of each.
Do something to be nothing more is now because we said that you. This.
Ask that you all return at 1:15.
Oh boy, we got
Please
another
remember the
PowerPoint
admonition.
presentation.
You are excused. Please be seated. The record will show the presence of the jury, the defendant, and all counsel.
Can't wait. Is there a dude running
Ms.
in a
Lamont, you may
hamster wheel? That's a deep cut.
People are far better than their very worst deed.
Mike Babicki.
And Jodi Arias is a far better person than her very worst deed. Each and every one of you have your own moral decision that you have to make. Each and every one of you have to decide for yourselves if, despite her very worst deed, her life still has value. Back in December, when we first started choosing a jury, we all talked to you and asked you that question about whether or not if you found that somebody was guilty of a first-degree murder and it was cold-blooded and awful,
in the background,
could you still
I can't believe she actually bought this
consider
crap.
giving that person life in prison? And each one of you said that you could. This phase is different. It's different because the state of Arizona does not require you to execute somebody for first-degree murder. There is no requirement. In fact, the state of Arizona, the laws of Arizona, are always satisfied with life in prison. When we talk in this phase of the trial, it is different because we are now talking about a different burden. This whole time, we have been talking about the burden of proof of beyond a reasonable doubt, and that the government had to prove to you beyond a reasonable doubt, a very high standard. But we're no longer talking about beyond a reasonable doubt. And in fact, now the burden has changed. The burden has changed to a much lower standard. And the standard is now preponderance of the evidence. And what the judge has told you about preponderance of the evidence is that the defense, we have to prove to you now by a preponderance of the evidence that any mitigating factor is true. Preponderance of the evidence is a lower standard, and what that means is that we have to prove to you that a fact is more true than not true. A much lower standard beyond a reasonable doubt. Those mitigating factors are a very personal decision for you. Each juror can choose to believe a different mitigating factor. And so when you go back to deliberate, each juror can come back with a different mitigating factor, believing that the defense has proven a different mitigating factor. In other words, there could be a total of 12 different mitigating factors that you find. You don't have to agree with your neighbor. Your decision is your own personal choice. It is your own moral choice, whether or not you find it to be more true than not, that there is a reason to find value with Jodi's life, that there is a reason to punish her with life in prison. You have every right to stand by your decision. And so whatever decision you make, you have every right to stand by it. You do not have to explain it to anybody else because it is your own moral decision to make. And remember, when we were talking to you back in December, when we first started choosing a jury, we talked to you about whether or not you could respect another juror's opinion. And that's what we're asking you to do now. Whatever your decision may be, it is your decision and yours to hold, and it is your personal decision to make. Mitigation is what we're talking about now. And the state has attempted to shape this case into something to be nothing more than lies and manipulation. Like somehow every word out of Jodi's mouth has been nothing more than a lie, and her own witnesses.
Yes.
That's
Correct.
what the state wants you to believe. And that somehow lying is appropriate now. That somehow the state believes because there's been lying that she should get the death penalty for that. But lying is not a capital crime. And lying does not get you the death penalty. And lying isn't even an aggravating factor. It doesn't even qualify someone to get the death penalty. Mitigating factors are reasons that give you a reason for you to believe that there is something of value in Jodi's life. A reason to say that you can punish her with life in prison instead of execution. Mitigating factors are not excuses, and that is not why we're up here. They are not an excuse for what she did. You have already convicted her of first-degree murder for that. So we are not up here to talk about excuses for why she did it. Mitigating factors are reasons why you can find that they are sufficiently substantial to call for punishment of life in prison.
But they were shite. Shite, I tell you.
Mitigating factors are completely unrelated.
The reason why the abbreviation
Completely
is MF.
unrelated to and separate from the first-degree murder conviction. And the judge read to you in those instructions that you have convicted her of first-degree murder.
Money.
You've done that, and we're this far. But mitigating factors have nothing to do with excusing that crime, and they're completely unrelated and separate now from the actual crime itself. Mitigating factors are reasons that you can find that are sufficiently substantial
I could talk over her and
to
probably
call
be okay.
for life in prison. It is very important to understand, and this is in your jury instructions, that mitigating factors are not reasons that have to be connected to the crime. You don't have to find any connection between a reason to give her life versus the crime itself. Mitigating factors are reasons that in fairness and in mercy, you can find that life in prison is the appropriate penalty. For example, if one of you were to believe that someone who commits a murder when they're under 30 years old, anybody who is convicted of first-degree murder who's under 30 years old at the time, I don't believe should get the death penalty. If that is a mitigating factor for you, if that is a reason that is sufficient for you to give that person life in prison, then that is your vote. That factor may have absolutely nothing to do with the crime itself. It may not be connected in any way, but that's okay. These are moral decisions for you to make, your own personal decisions. Mitigation comes in two forms. There are good things about a person's background and their character that they have done before. And there are bad things. There are things that have happened to that person that have somehow changed the trajectory of their life, who they could have been if it weren't for these things. Let's talk about some of the good things about Jodi. Things that show that she has value still in her life. Jodi was just 27 years old when she killed Travis. And at the time that she did it, she had no prior criminal history. And I want to be clear about that. No prior criminal history means she's not been convicted of anything else before in her entire life. And when we talk about prior criminal history, we're not talking about someone who lies.
You know what? I'm going to let it keep going.
And who has lied in the past. Prior criminal history isn't about lying. It's about the type of criminal who goes out, commits a crime, gets a second chance, commits another crime, doesn't care about the person that they've hurt because they continue to commit the crimes over and over again. The type of person who commits a crime and gets a second chance, gets a third chance,
and do what
gets
Jodi
a fourth
did.
chance. Those are people with criminal history.
It doesn't matter.
And Jodi does not have one. At the time that she did this, she had no criminal history, not until this conviction. That is a mitigating factor, and that is a reason to show mercy and to give her life in prison instead of being executed. Another mitigating factor, another reason to consider giving her life in prison is the fact that Jodi was a good friend, that there are people who care about her. And when we talk about these people, you heard them when they testified during the guilt phase. You heard from Daryl Brewer when he testified about his relationship with Jodi and that they were together for 4 years, that he loved her. You heard that he was getting past a very bitter divorce and that he was very hesitant with his son, protective of his son. But he trusted and loved Jodi enough that they became the three of them. And they were together all the time, taking trips together.
We were a one-man wolf pack. And then I found the other, and then the one-man wolf pack became
Jodi also
a two-man wolf pack. And then that
Jodi
one
also has friends when we talk about the other people who've testified, the people who have told you that they were shocked, that they would not have expected this to happen. And those people were the state's witnesses. Remember Leslie Udy, who talked to you about Jodi's personality and what she thought of Jodi and how she thought she was sweet, and how on this stand she told you that she couldn't believe Jodi would do something like this. She was shocked. You heard from Ryan Burns, the person that Jodi went to go see after Travis. You heard from Ryan that Ryan told you that when she would come to these PPL meetings and these Super Saturday meetings, that these people enjoyed her, that she got along well with people. Some of you may be asking yourselves, what does it honestly matter if she was a good friend? Why? Look what she did to Travis.
It doesn't.
What does it matter now?
That's what we're wondering.
It matters because the prosecutor wants to paint her as a one-dimensional character. A one-dimensional character who is defined by nothing else other than what she did to Travis. They want to do that because it makes it easier for you to execute her. But she is not a one-dimensional character. She had made so many other people happy in her life prior to coming here.
Here we go.
Could it be?
You heard from Desiree and Dan Freeman. Desiree and Dan Freeman testified during the guilt phase. They both told you that they took trips with Jodi and Travis, that they went to Havasupai Falls, that they went to the Grand Canyon together, that they enjoyed spending time with her. In fact, Dan Freeman told you that Jodi used to come to his house for dinner on Sunday nights, and that they treated her like family, and that Dan considered her like a sister. You've seen Jodi's family here, day in and day out. and they are here for her now. And Jodi asked you during her allocution to consider them. We know also another reason that gives value and adds worth to Jodi's life now is the fact that she has always tried to improve her life. She has always tried to make the best of her life. You heard from Gus Searcy during the guilt phase, and he told you that she was the utmost professional at PPL, that she worked very hard. You heard from Daryl, Mr. Brewer, that he told you that she was very responsible, that they bought a house together, and that she was always working. The prosecutor wants you to believe that these qualities don't add value to Jodi's life, that they don't make it worth saving. But nothing could be further from the truth. Because if she is given the chance for life in prison, she will continue working to improve her existence and to add something to this world. And she talked about some of those things, like she's done already while she's been awaiting trial. Over 3 times she's been able to grow her hair long enough and give it to Locks of Love, which is for people to get wigs who've gone through cancer and chemo. She doesn't have to do that. But that shows you something that is valuable in her life. She has goals. Even in prison, she can have goals. And the fact that she's thinking ahead of what she can do for this world still is important and valuable. She has the ability to teach people Spanish. She wants to know, she knows that illiteracy is a problem in this country. And she knows that she has the ability to teach people to read and to write. With her, we know that she's an amazing poet, an artist, and an excellent writer. She wants to use those talents to be able to dedicate to the domestic violence awareness and to help people become aware of the problems with domestic violence. These are all goals that she has. And while they may seem silly and contrite when you look at what's happened with Travis's family, these goals are something that would be completed behind bars, in prison, not to get out. This has been a shock to the people that knew Jodi. And you heard that even from the state's witness, Leslie Udy. It has been a shock to think that she was capable of such violence. And she told you this morning that it's a shock to her, but that she knows she did. And so what we have to look at is why. Not excuses, but why. We have to look at what changed the trajectory of her life. What is it that made her come here?
She killed somebody.
Given all her talents, she could have been a famous artist. She could have been an excellent saleswoman.
No.
She could have been a defense attorney sitting next to me.
No, ma'am.
But she's here.
No,
sitting next to me as a defendant.
Yep.
What changed the trajectory of her life?
She unalived somebody. Asked and answered.
When Jodi was a little girl.
Objection irrelevant.
It was just her and her little brother, Carl. They would play together all the time, chase each other around in the yard, having a great time, not come in until their parents called them in. At that point in Jodi's life, when she was just a few years old, she could feel the love from her mother. She felt that every time that her mother held her, that her mother fixed a scrape from tree climbing, she felt that every time that her mother read her stories. But a few years from that all changed. It all changed when she and her mother grew apart, when they were no longer getting along. When her little sister Angela was born, things changed. Jodi could feel it. Jodi all of a sudden was no longer getting along with her mother. She couldn't do anything right in her mother's eyes. She was getting grounded for inexplainable reasons. And when that happened, everything changed for Jodi.
Oh, yeah.
As her relationship with her mother grew further and further apart, she watched. She watched how her dad treated her mom. And as Alice LaViolette told you, she learned the language of that household. She learned what happens. She watched her dad yell at her mom. She watched her dad ridicule her mom. She watched her dad tease her mom with cruel jokes. But through it all, her mom stayed. And from that, Jodi learned loyalty. No matter what happens, you remain loyal. We know from all the psychological testing that was completed with Jodi, we know one thing for sure, that she has a very low self-esteem, almost no ego. We know that she suffered from depression, starting with her teenage years. And so on that day, when September 2006, when Travis came striding over with his arms stuck out, ready to meet Jodi, Jodi was already in a vulnerable position. She was in a relationship where she wanted more. She wanted a family, she wanted children, and Daryl just wasn't at that point where he could give it to her. On the other hand, Travis talked about himself and about his strength in religion and how much he believed in families. Jodi thought he was perfect. They spent time together that weekend, and he impressed her when he took her to the executive director's banquet. The only way she could go was to be invited. And so a week later, when he wanted oral sex, she gave it to him because she didn't want to lose what she thought she had was so good. And a week after that, when Travis was sending over Mormon missionaries to her house in Palm Desert, she sat and talked with him every week until ultimately she converted a month and a half later. Jodi put Travis on a pedestal. She believed in him, she trusted him, and she loved him. She saw all the wonderful qualities that his family already knew he had, and she loved that about him. But she also saw the other side of him. Whether you believe that Travis physically abused Jodi or not, we know that he verbally abused her. We know this because you've seen the hateful words. You've seen what they have said. And it isn't just that he said these hateful words to her, it's the fact that he would say them one day, hateful one day, and then loving the next day. It was a constant yo-yo. I don't know how your heart beats in such a corrupted carcass. I hate you. You are the worst thing that ever happened to me. And then the next day, I love you. I'm sorry. You are the most beautiful person inside and out. You have to know that if Travis were sitting next to me in this case, the prosecutor would be using those same words, those same hateful words against him.
Could it be?
And so, yes, there has been lying in this case, absolutely. And Jodi started with the most powerful lie that she told to herself. The lie she told herself about her relationship with Travis. The lie that you look into a mirror and you look at yourself and you say things that are not true, that are not the way they really are. No matter what anyone else argues, no person truly wants to be treated like that. No person truly wants to be called those horrible names. Don't be fooled into thinking that somehow Jodi wanted to or deserved to be treated like that. But I want to be clear. It is not an excuse to kill Travis. And by talking about Travis being verbally abusive to Jodi, we're in no way saying that that is an excuse to kill him.
And yet here we are.
It absolutely wasn't. And you have already convicted her of first-degree murder for killing him.
Kirk's in the back like a kid, the smart kid in a group project.
But
who's
abuse
like,
is a mitigating factor.
nothing to do
It is
with
a
this.
reason
Not
to
me.
find that it changed the trajectory of her life. Look at how she reacted with Daryl. Look at the solid relationship she had with him for 4 years. And they were still friends after their relationship. Mitigation in this is important to understand what changed the trajectory, what caused Jodi to be here. With all of this,
Are we back to that question again? That was
verbal
asked and
abuse.
answered.
knowing that it is not an excuse for what she did, Jodi handled it the only way she knew how.
What?
She lied. She lied to herself. She lied to herself when she would pretend that those words didn't hurt. When she would pretend that those words didn't really matter.
Be quiet.
And when she would pretend that those words, that he didn't really mean it.
You get nothing.
She lied.
You lose. Good day, sir.
And so when she did the very worst thing
She
that
blue
she has
screened.
ever done in her life, and she told you this
Blue
morning,
screened out.
it is something worse that she could never even imagine doing something so vile. And when she did something like that, so bad that she couldn't even accept that she did it, she lied. She lied to herself. She lied to the detective. She lied to the media. And she lied to Travis's family. But despite those lies
There's no
about
despite.
killing Travis, it does not diminish the abuse that she went through. It does not equal execution. She was once a bubbly and happy little girl. Somebody who always had a nose in a book. Somebody who loved to write in her journals. And somebody who loved to spend her days reading. She will be haunted by what she did. By what she did to Travis's family, by what she did to Travis, and by what she's done to her own family. She is haunted by that. What is so tragic about this case is that if either one of them would have sought help at some point for the type of relationship they were in, none of us may never have been here. And so we have to look at what else changed the trajectory of her life. We know that the state's own witness, Dr. DeMarte, came in and told you that Jodi suffers from borderline personality disorder. She told you that people who have borderline personality disorder,
Notice
often
they
it comes,
haven't
it
quoted
results
Samuels
from
yet.
a child who does not have their feelings validated by their parents.
Check,
A child
please.
who does not bond, who's not able to bond with their parents. She told you that people with borderline personality disorder often have an immaturity about them and that they're prone to violent outbursts. Is that what happened here? Because if so, Jodi cannot choose to have a personality disorder or not. It
She
is
would have
not
had
her
to be
choice.
good at that job.
In other words, she didn't wake up one morning and think that it would be great to have a personality disorder. It is not something that people can choose when they have mental health
Oh my
problems.
God, who the hell cares?
We know that it wasn't just Dr. DeMarte. We know that it was Dr. Samuels who told you also that she
there it is.
suffered from a personality disorder that was not specified. And we know that Dr. Geffner told you that a person can have PTSD and borderline personality disorder at the same time. They are not mutually exclusive. Having borderline personality disorder, having any personality disorder is not an excuse. It is not an excuse for what she did to Travis.
So why are we talking about this?
But it is a reason. It is a reason that you can find that is sufficiently substantial to call for life in prison. It is another reason that you have to be merciful.
Stupid idiot.
There is so much mitigation in this case. There are so many reasons that you on your own individually can find to be merciful. That you on your own can find that are sufficiently substantial to call for life in prison instead of execution. And there is just one aggravating factor, just one. The strongest mitigating factor that you have before you is the fact that she has no criminal history. This is not something that she was doing over and over again. And while what she did was absolutely horrible, you have convicted her of that. Jodi took Travis away. She took him away from his family, and she took him away from this world.
Certified bunny boiler.
But two wrongs do not make a right. Jodi can still contribute to this world. Her life still has value, and you have a choice. A well-known attorney once said, when with imagination and understanding and faith, we can look inside our own hearts and find that all life is worth saving, and that mercy is the highest attribute.
You
We are
haven't turned
asking
it
you
in
to find
yet?
that Jodi's life is worth saving. And to have the ability to understand that despite her very worst deed, you can still show mercy and find that she still has value in her life and sentence her to a term of life in prison. Thank you.
Oh, thank God.
Mr. Martinez.
Judge, if we could have the Elmo, what used to be called the Elmo.
Yes.
What used to be called the Elmo. Here we go. And here we go. I want Juan to go up and go, you heard that, right? All right, go do your thing.
To his family, to people that spoke to you, Travis Alexander will be forever young. You have been shown many photographs here of people going through the stages of life and how they've gone from children, they've gotten older, and you've seen the progression of life. But to his family, Travis Alexander will be 30 years old for the rest of his life. And as they told you, they tried to remember him as he was when he was in life. In fact, they tried to remember him as in Exhibit 661. That smile and perhaps that twinkle in his eye. And they told you You know, we try to remember him that way. They talked to you about that during their victim impact statement. But they also told you
now, Jodi.
that they couldn't forget. Even though they remember him this way, they can't forget. They can't forget what happened on June 4th of 2008. They can't forget that on that afternoon, Travis Victor Alexander suffered immense physical pain. They can't forget that he suffered extreme emotional distress. They can't forget that. And they can't forget that it was especially cruel. And that is something that you shouldn't also forget as you debate or you decide this case. You shouldn't forget what you saw in exhibit number.
Objection, Your Honor. Really push.
You should not forget as you deliberate this and determine whether or not there are mitigating circumstances and whether or not you should consider them. You should not forget exhibit 205. Because as his family told you, they haven't forgotten that. And that exemplifies or sets out this especially cruel crime. Especially cruel in the sense that it hurt, extreme pain, and extreme emotional distress. And that is what you need to take back with you when you are attempting to take a look at some of these mitigating circumstances that they have proposed for you. One of the things that they've argued to you, and one of the things that they told you, first of all, in their opening statement, and now also when the defendant allocuted, and as well as in the presentation that you just heard, that she is going to spend the rest of her life in prison. Although it's not listed as a mitigating factor, they did indicate to you that you could look to the circumstances to see if you find any mitigating circumstances on your own. The state cautions you that you are not private investigators or advocates when you go back into that jury deliberation to do your duties as jurors. What you're back there to do is to find the facts. You don't advocate one side, you don't advocate the other. You don't go out on a limb and you don't investigate this to see whether or not there are any mitigating circumstances. For example, in this case, as you saw with Mr. Alexander, he is dead. And one of the things that you could find if you were being an extreme, and I'm saying an extreme advocate, is that you could say, well, he will never suffer cancer. Cancer is a horrible disease. She saved him from that, didn't she? Well, you could say, well, that's going to an extreme. It is going to an extreme, but it illustrates the point that you are not an advocate when you go back there. In terms of this case, there are no mitigating circumstances that you can find with regard to the crime. They also tell you, well, she's going to spend the rest of her life in prison. If you remember when you filled out the juror questionnaire way back on December 10th or a couple of days after that.
Objection, Judge Newby.
They made the argument that she's going to spend the rest of her life in prison should you choose that option. But I ask you to think back to the juror questionnaire, one that some of you began filling out back on December 10th of 2012. And in it, it explained to you what the parameters or what this life meant. You were told that life in the state of Arizona meant two things. Yes, it could mean natural life, that the individual who is sentenced does not leave the Department of Corrections until their death. But that juror questionnaire also told you that an individual who is sentenced to life is eligible for release at the expiration of 25 calendar years. So when they speak to you about life, and when they talk to you about that as a mitigating circumstance, consider that as part of the argument, and consider that when you're looking at the rest of the mitigating factors that were proposed to you. And there were 8 mitigating factors that you were asked to take a look at. For example, one of them was that she was a good artist. And in fact, during her allocution, the defendant actually showed you some of her artwork. There was a diagram or a sketch of Frank Sinatra, was one of Elvis Presley, and there was a couple of others that you were asked to look at. Because somehow, if you have a skill, you are entitled. Somehow those that have a skill get an easier path. Just because they are skilled, don't you know? That's something that you should take into account, even though all it is a skill. It's an entitlement road that they want you to travel. When they talk to you about the fact that she's a good artist, doesn't mean anything. All it means is that give her special or preferential treatment. That's what that means, and that is not a mitigating factor. They also tell you, well, she was only 27 years of age at the time that she murdered Mr. Alexander. Last time that anybody looked, the age of majority was 18 in the United States. People go fight wars at the age of 18, but they want you to take a look at the fact that she was 9 years post her 18th birthday. Additionally, if you take a look at her life itself, they sort of stood up here and told you what a grand relationship she had with this individual named Daryl Brewer. She was having a relationship that shows that she enjoyed life. She knew what a good life was. She also had parents that were loving when she was growing up. All of this sort of goes into the mix.
Nonverbals do not
in creating
deny
an
what he
individual
just
that was
said.
27 years old. Somebody that had previous employment, somebody who was intelligent, somebody who had been through other love affairs and had had a vast array of life's experiences at the age of 27. She wasn't 18, she wasn't 19 years old, she wasn't anything like that. She had already experienced life. So that is not a mitigating circumstance. At the age of 60, they could make the same argument to you.
appreciate that he
At
took
the age
these
of
one at a
55,
time
they could make the same argument
and
to you.
destroy-
She was only 60, she was only 55 years old. Yes, you consider the age, but you also look at the life's experiences that are associated with that. And she had lived, at that point, a very full life. As she indicated herself, she had experimented sexually. She had had friends, according to her. She had had a good family. She had been out in the world on her own, and in fact was living a good life with Mr. Brewer out in California. So when you look at that, yes, she was 27 years old. And she is 32 years old now. But Travis Alexander, he's 30 years old. He's still, today, 30 years old. And the person responsible for that stood before you in court and asked you to take a look at that. Only 27 years old. Well, Mr. Alexander only was 30 and will be forever 30. She showed you pictures of her yesterdays. She showed you pictures of her growing up. Mr. Alexander is no longer going to have any more yesterdays.
Objection, Your Honor.
He's not going to have or be able to enjoy the experiences that she was telling you that she is going to miss. Holding a nephew, she told you. Missing Christmas. She told you all about that. And she showed you a photograph where they celebrated the Christmas with her there via a photograph. But Mr. Alexander.
Objection, Judge Bailey, approach.
She told you about how she's going to miss all these Christmases. She told you about how it is that there's only going to be this photograph of her every time that her family meets. How is that a mitigating factor? When you take a look at the absolute horrendous violence that she heaped or put on Travis Alexander. So no, the fact that she was 27 years of age is not a mitigating factor. Additionally, she also told you that she doesn't have any prior criminal history. And they told you, well, she's never done this before, so that shows what a good person she is. Well, if you take a look at that particular argument, usually people when they kill in this horrendous fashion, usually the police go out and arrest them so as to not give them the opportunity to do this again. So when they tell you she never did this before, really that is not a mitigating circumstance. Additionally, a criminal history talks about, if you will, an offense to the public good or to the public order. Because if everybody were allowed to commit offenses, you would have anarchy in society. That's the part of the reason.
Objection, Your Honor. Improper argument.
We're talking about what a crime is. And one of the things that they told you, she doesn't have any history of this. Well, actually, if history is what we're talking about, weren't you present for some of that history? Weren't you present when she sat in that witness chair after taking an oath to tell the truth, the whole truth and nothing but the truth, and look each and every one of you in the eye and started to talk?
Objection, Your Honor. Improper argument.
Overruled.
And talk to you about the events leading up to the crime. Specifically, she talked to you, for example, I'll just pick one, the example about the gas cans. Well, most of you know what perjury is. That doesn't mean that she has been convicted. No one is saying that. But just because you're not convicted does not mean that you have not engaged in criminal conduct.
Objection, improper argument.
Overruled.
And with regard to her lying, they told you
You'll
during
get
their
one day,
as well.
Mr. Wilmot.
Yes, after this happened, she did lie, and she lied to the police over and over again. Well, isn't that also a crime to
They're
lie
trying
to
to
the
break
police
this
during their
flow, and you
investigation?
can't do it with one.
But again, don't look to
Right.
that. Just look past that. Just look to what we're alleging, that there is no criminal history. There is a history here. There is a criminal history, and this is
Objection,
not.
improper argument.
Overruled. You may finish your sentence.
And this is not a mitigating circumstance. She also tells you that she was a good friend. And one of the things that we have to keep in mind here is that when we're defining friend, what does friendship mean? Doesn't friendship imply that you know the person better than most people because you have sort of a relationship where they confide in you and you confide in them, and then you sort of have this sort of bond between the two of you? And they held out the fact that she was friends with Leslie Udy about this, and that Leslie Udy said, well, I would never have thought that she had done something like this. But wasn't that bond, if you will, between her and Leslie Udy one based on a lie? If you remember when the defendant went up after she killed Mr. Alexander, she went and spoke to Miss Udy. And what did she do? Well, she lied to her. And she told her, you know, when Mr. Alexander and I get married and we have kids, I want our kids to play together. Is that really a friendship when one person is lying to the other person? That is not what a friendship is. They also mentioned the fact that she had a friendship with Ryan Burns. That's the other thing that they pointed out to you. Well, if friendship means adjusting somebody, then maybe it could be a friendship. But she said that didn't happen because according to her, Mr. Burns is full of crap. That's exactly what she said. But again, when she spoke with Mr. Burns, again, she lied to him. Again, she didn't tell him the truth. So is that really a good friend who will come up to you and lie to you? No, that is not what a friendship is. And so if that is the friendship that they're basing it on, then this is not a mitigating factor. And again, all of this that is being presented to you during this phase of the proceedings, most of it has come from the defendant's mouth. This individual that will not hesitate when the truth fails to come up with a lie. And so when you look at that and you see this allegation that she has a good friend, and then you say, but she's the one that told me. The bottom line then is that really a mitigating factor that has been proven by a preponderance of the evidence? And there is a standard here. Is it more likely than not that when this individual here in court tells you that she has a good friend that for whatever reason couldn't be here, is that something that, based on everything that you see and judging the credibility of her as a witness, is that something that has been proven to be more likely true?
Approach.
This issue of why Patricia Womack isn't here was raised during the allocution. And this issue was raised by the defendant. Again, consider the individual, consider her credibility when you are attempting to assess or determine whether or not there is a good friend out there for the defendant. Nothing in the sense that there has been a preponderance of the evidence that has shown you with regard to this issue that the defendant has a good friend. The defendant also tells you that with regard to another mitigating factor is that she lacks support from her family. And then she talks about the other side of her mouth and says to you, well, they've been here throughout this whole trial. Well, which one is it? Have they been here throughout this whole trial or have they not? Have they failed to support her or not? Well, we know that the evidence has shown, for example, back in August of 2007, that when the defendant had issues with peeping in the window into Mr. Alexander's home
Overruled.
and saw him with another woman after they'd broken up, what did she do? She contacted her father and he supported her. And she indicated by her own words, maybe she's forgotten about it, that he was very supportive. When she was going to move back, who did she call? She called her mother. And she called her mother, and her mother came out here to help her move. Additionally, she talks about her brother in very glowing terms. So she did have this family support. She has not proven that by a preponderance of the evidence. Again, you don't just consider what she says here in allocution, you take a look at the whole panorama that you have before you so you can get the full vista of this individual's life and the full vista of her statement of the allocution as part of this whole view of her universe. She also, again, goes over this issue about suffering abuse and neglect as a child and as an adult. Presumably what she's talking about when she talks about abuse as a child is at the time that she liked to play the victim. At the time that she liked to play the victim even though she wasn't a victim, according to those that were growing up with her. And at a time when she was manipulative and used to like to manipulate people. That's the kind of individual that's telling you, well, no, I was abused. Additionally, there are no school reports of any abuse. There are no medical reports of any abuse. There are no police reports of any abuse. There isn't.
Objection is inappropriate. That's not true.
You asked for approach?
Yes.
Yes, you may approach.
We talked about this issue during the guilt phase of the proceedings, and that's what the evidence showed, that there was no reports of any kind, none whatsoever, with regard to any abuse at all when she was a child. The only thing that we have is somebody that was growing up with her saying that, well, the defendant likes to play the victim, even though she was never abused. And that's according to Alice Laviolette. As an adult, of course, they want to rehash, replay, continue their frontal attack and to smear Mr. Alexander. And they,
Objection, Your Honor, inappropriate.
Overruled.
and she indicates to you during her allocution, that was never my intent. I wanted to keep it quiet. But are there any, as we determined during the guilt phase, are there any medical reports to support it? Are there any police reports? Are there any 911 calls? And she tells you, well, the reason that there were no 911 calls is because earlier on, when I did call and I was in this relationship with Mr. Juarez, nobody came, so therefore I didn't call. There is nothing to corroborate this. And so they have not carried their burden by a preponderance of the evidence, more likely than not, that she suffered any abuse as a child or as an adult. And then they tell you that, well, with regard to 6 and 7, she tried to make the best of her life and that she's trying to improve herself. If you take a look at that statement, what it actually is telling you is that she's just going through life. But isn't that what everybody else is doing? There's nothing special mitigating about it. Don't most people want to improve their life? Don't most people want to make the best of their life? She's doing the bare minimum, the absolute bare minimum that everybody does. People try to do the best in their job. They try to do the best in their relationships. She's doing the bare minimum and want you to look at that and say, aha, that's a mitigating circumstance. when a mitigating circumstance, when all she has done is met the minimum requirement. None of these are mitigating circumstances. And if none of these are mitigating circumstances, then the jury instructions tell you what to do. And they tell you what to do if that is the case. If all of you find that there are no mitigating circumstances, then you have a verdict to find. It is in the mandatory form. There is no discretion as to what verdict you are to return if you find that there are no mitigating circumstances. But some of you may say, well, maybe some of these may be mitigating circumstances, although the state disputes it. But the jury instructions tell you that in determining whether or not life or death is appropriate, and if you do find mitigating circumstances, any connection or lack of connection may impact the quality and the strength of the mitigation evidence. So if you find, for example, that being a talented artist is a mitigating circumstance, what does that have to do with the crime? That affects the quality or the strength of that mitigating factor. The same thing with regard if you find that 27 years old is somewhat a young age. How does that affect the crime? How does that affect the strength or the quality of that mitigating circumstance? It shows you that they are not worth considering when you take a look at the horrific nature of the killing. If you find that she does not have any prior criminal history and you find that that's a mitigating circumstance, even though she has committed other crimes, again.
Objection. There is no prior convictions.
Overruled. You may continue.
It doesn't have anything to do with the crime. And the same thing with being a good friend, or that she lacks support from her family, or that she was neglected as a child and is trying the best to improve herself. Under both of those scenarios, and those are the scenarios that you may have, where none of these are mitigating circumstances, or some of them are mitigating circumstances, as you may find them. But if you find that some of them are mitigating circumstances, they don't have any connection to the killing, and therefore they are not entitled to much weight. The state's position, they are entitled to no weight. But once you have that, jury instructions tell you that in reaching a decision, you have to engage in a sort of analysis. And this analysis that you are to engage in is no different than the analysis that you undertook with regard to the first phase of these proceedings. You took a look at the facts, you took a look at the law, and then you applied it, and then you reached your verdict. The same thing with regard to the second phase involving whether or not this crime was especially cruel. You looked at the facts, you looked at the law, and then you applied them, and then you reached your decision. That is exactly the same thing you are being asked to do here. You are asked to determine whether or not this mitigation, if there is any, because if there isn't any, that ends your inquiry. But if there is this mitigating or these mitigating circumstances, you are being asked to determine whether or not they are sufficiently substantial to call for leniency, and that means the mitigation must be of such quality or value, again, whether or not there's this connection, that it is adequate to vote for a sentence.
Well, isn't that special?
Sufficiently substantial to call for leniency. Nothing that they have presented here, nothing that has been presented in any of the phases is a mitigating circumstance. But if one or two of you, or perhaps more than that, find that one of these factors that they set out for you, of these 8, is a possible mitigating circumstance, is it sufficiently substantial to call for leniency when you take a look at what this individual did? And in this particular case, applying this to this particular case, and though they've talked to you about the ages and they've talked to you about everything, when you take a look at that and you consider that, and you can consider victim impact statements when you make this determination, one of the things that you will take back with you is that Travis Alexander will never be more than 30 years old. That is his age. This individual in Exhibit 661. That's it. That's as old as he is going to get. And taking into account that there are no mitigating circumstances, and even if you find some, it is not sufficiently substantial to call for leniency in this case. And in applying the law to the facts in this case, to the so-called mitigating circumstances, considering the allocution in this case, you have a duty. And that duty really means that you actually do the honest, right thing, even though it may be difficult. And in this case, the right thing, the difficult thing in this case, and because it's never easy, her duty, the difficult thing to do under these circumstances, the only thing that you can do based on the mitigating circumstances and their lack of, is to return a verdict of death. Thank you.
The simple question that's before you is, do you kill her? That's the question. She has done something very bad. She did. And you have convicted her for that. You have told her that she is guilty of first-degree murder for that. But the question is now, do you kill her? When we talk about mitigation, aggravation, the point of it all is, does she have value? Is there something that you as an individual person believe is worth saving her? Is worth her living her life in prison? The prosecutor talked to you about living her life in prison and how there's a possibility that after 25 years, there could be parole. You are not supposed to consider that, and that should not enter into your decision of whether or not to give her life or death. In fact, the last time somebody was paroled was eons.
I'm going to hold back my objections.
Sustained.
The prosecutor wants to tell you that her age doesn't matter, that her lack of criminal history doesn't matter. But those things absolutely do matter. We're not talking about whether or not to convict her. We're talking about whether or not to kill her. And so when we talk about that, it matters that she was 27 years old and that she had no criminal history. It matters that she hadn't done anything wrong in her life before that.
Brilliant.
It matters when you make that decision to give her life in prison. The prosecutor wants to talk to you about that she has some kind of entitlement feeling. Entitlement, because she's an artist and therefore she's entitled to live. That is absolutely false. There is no entitlement feelings here. It's quite the opposite. It's begging. It's begging for her life at this point. There is no entitlement. The fact that she's a good artist is something that any one of you may feel that it is worth saving her life for, that it is worth keeping her around because she can provide some type of value to this world.
Nope.
When the prosecutor talks about criminal history, she doesn't have any. And so all he can come up with is the fact that she's lied. We know she's lied. Absolutely she's lied. That's been this whole case. His lies and manipulations. That's been the entire case. But lying is not a capital offense. We're asking you not to sentence her to death because she lied. You have convicted her of first-degree murder. She does not need to be sentenced to death because of the lies. He talked about friendship and the fact that it's not important, that it does not add value, and that these friendships were somehow based on lies, again with the lies. But her friendships were not based on lies. You know, Daryl Brewer and she and Jodi had a wonderful relationship for several years. What that shows you is the fact that something happened. Something happened that changed the trajectory of her life, changed what she could have been. The prosecutor wants to talk to you about the lack of support from her family, but yet they're here. So that's not a mitigating factor. Her family was not there for her when she needed them. And it's sad, and it is so hard to say when they sit right here and have to listen to that. But you know what? When she was a teenager and she needed them, they were not there. And you know how we know that? We know it because she has borderline personality disorder. We know because Dr. DeMarte told you that's what happens. Lack of bonding, detached from parents. That little girl needed someone and she didn't have them. And so absolutely they're here now, and thankfully they are. But the fact that it changed the course of her life is important for you to consider. And it is a reason for you to be merciful and give her life in prison.
Thank you. Close it. You're done. It's over. Bye. No, we're done. We're done. No.
The prosecutor wants to remind you about the one statement that came out in this case, that she liked to play the victim. Jodi has not played the victim. And in fact, you heard during trial that that statement came from a girl who knew her between the ages of 1st grade and 5th grade. That's what he wants to base your decision of life or death on, is from a person who knew her between 1st and 5th grade.
Preemptive shh.
Someone who he didn't bring into trial.
With your name on it.
He wants to tell you that she's doing nothing but the bare minimum in life. That doesn't add value to her life. Because she was doing what all of us do. The point of the fact that she can add value, the fact that she has something to give to this world is important. The fact that she looks beyond her current situation and has a hope to contribute to this world still is important for you to consider. It is an awful, awful thing that she did. And Travis's family is certainly suffering for it. But your conviction of 1st-degree murder is why, or is how they have been, hopefully, get some peace.
Somebody get this.
Your conviction of 1st-degree murder speaks to what she did. And there's no disputing that at this point. We're not explaining it. It is what it is. The question now before you is, do you kill her? Do you kill her for the one act that she did, the one horrible act? Or can you see that there is a reason to let her live? Can you see that there is still value in her life? Can you see that there is value and love from her family? She won't be living with them. And she won't be living with any of us. But she will be living in prison. And even there, she can contribute to this world. We are asking you to find mercy. To find that these mitigating factors, these reasons to show mercy, to find value in a person's life, and to find that Jodi's life, despite what she has done, is worth saving. We're asking you to give her life in prison. Thank you.
Okay, bye.
Ladies and gentlemen, please turn to page 11 of your instructions. Please advise the bailiff, them, or wish to verdict on which to impart. At this time, jurors number 10, ladies and gentlemen, I have received your note indicating that you are unable to come to a unanimous decision. I have some suggestions to help your deliberations and not to force you to reach a verdict. I am merely trying to be responsive to your apparent need for help. I do not wish no areas of
Your parent
agreement
needs
and
help.
doubt and try to help. All right, we're on the record. Record will show the presence of the defendant and all counsel. The court has received a juror question. It has been marked as juror question number 3. All counsel have had an opportunity to review the question as well as the proposed response. Is there any objection from the state to the proposed response?
No.
Any objection from the defense?
None, Your Honor.
All right, the juror question and response will be returned to the jury by the bailiff. All right, anything else at this time?
No.
All right, thank you.
Oh, well done.
Please be seated. The record will show the presence of the jury, the defendant, and all counsel. Ladies and gentlemen, I understand you have reached a verdict. The bailiff will please approach with the verdict.
Oh, thank you. Oh, she lost her glasses. She apparently can see near and far.
The clerk will read and record the verdict.
State of Arizona versus Jodi Ann Arias, sentencing verdict. We, the jury, duly impaneled and sworn in the above entitled action upon our oaths, unanimously find, having considered all of the facts and circumstances, that the defendant should be sentenced. No unanimous agreement. Signed, 4-person. Is this your true verdict, so say you want to know?
Yes. The bailiff will ask the clerk will ask each of you a question. Please answer yes or no.
Juror number 1, is this your true verdict? Yes. Juror number 2, is this your true verdict?
Yes.
Juror number 3, is this your true verdict? Yes. Juror number 4, is this your true verdict?
Yes.
Juror number 6, is this your true verdict?
Yes.
Juror number 7, is this your true verdict?
Yes.
Juror number 9, is this your true verdict?
Yes.
Juror number 12, is this your true verdict?
Yes.
Juror number 13, is this your true verdict?
Yes.
Juror number 14, is this your true verdict?
Yes.
Juror number 16, is this your true verdict?
Yes.
Juror number 18, is this your true verdict?
Yes.
It is ordered declaring a mistrial as to the penalty phase. Will be ordered setting a retrial on the penalty phase for July 18th in this division. It is ordered setting a status conference in this division on penalty phase matters for June 20th at 8:30 a.m. Ladies and gentlemen, on behalf of the participants in this trial, I wish to thank you for your extraordinary service to this community. This was not your typical trial. You were asked to perform very difficult responsibilities. The admonition is now lifted. You are free to talk about the case or not talk about it as you wish. I will be back shortly to personally thank each of you for your service. You are excused.
Please stand for the verdict.
All right. It was a tad anticlimactic. I'll try and find the one where she actually is sentenced. It wasn't a mistrial on the actual guilty plea. It was a mistrial on the sentencing because the jury apparently couldn't come to a consensus. And they were like, yeah, there were three things. They went through it 3 times. 3 times. Because apparently, the first 2 weren't traumatizing enough. I'm just glad they don't have to do a full reset, like pull the cartridge, blow on it, put it back in, and hope that your spot's saved. So, I'll try and find a couple things for the beginning of Wednesday. However, Wednesday we will begin the next trial, which is Joel Guy Jr. And if you go back and go to the playlist on our channel, you can fast forward to me reading one of the documents, which explains some of what they found. We'll see probably in the trial, but that is sure to be fascinatingly horrific. But I think we're all ready for something new and fresh. But that technically wraps up the first the first trial Night Court's covered. Oh my gosh. Joel's a lot shorter, y'all. A lot shorter. So, thank you so much. We're gonna hang up the old phone, so that our mods can get some sleep. We got a big day tomorrow. Brandi and Day Court are gonna be covering Shabusiness's sentencing. Hopefully that goes a lot better than this one just did. And then in the afternoon at 4 p.m. Eastern, she's going to be having a big old Murdaugh fest. It's just a big old Murdaugh fest. Somebody asked, when did we start the Jodi trial? That's a great question. Let's see, shall we? And then we'll end it. Do. Where are you, Jodi? There you are. No. Let's go back. Let's go back to day one. Day one, when I had 1 billion hours and apparently a bunch of 4 months. It was 4 months ago. 4 months. So that's what happened. Here we are. It's been 84 years. But doggone it, we made it through. We made it through together. You guys, you all have become the best community on YouTube, the best late night community on YouTube. And I appreciate you guys spending your nights with moi and each other and trials. I don't know, Night Court's obviously doing Joel Guy, but I don't know, I don't know where we're going to go after Joel Guy. I don't know what this show is going to be. I'm still working on it. I know we like trials, but also I know that you guys are probably pretty tired and worn out of trials by the end of the day. So maybe this is another, maybe this is a chance after Joel to see what we could do next. If you have suggestions for what you'd like to see on Night Court, whether it be segments or features or anything like that, you're more than welcome to email me. You can message me on Discord. And I am going to be recording. I'm going to be recording a few guided meditations for my channel, and that'll be so if you got kids, this is going to be for students. OKC Jim asked me if I would record some stuff for her 6th graders. So I'm going to be doing that, and I will be posting them on YouTube as well. And so you can use them for your kids or you, however you want. Well, everybody, that wraps it up for Jodi as well as Night Court. Night Court is adjourned. I appreciate you. Please take care of yourself and take care of your friends and family. Don't forget to smile. As Pantoufle says, don't let anybody dull that sparkle. And shine on. Shine on, you crazy diamonds. Shine on.